if I put myself up on the screen? That would be, I think that would be the right thing to do. There we go. There's me. So, off for another fun-filled matter of covering the Michael Barisone trial. And this is the trial, of course, that involves the horse trainer, Michael Barisone, on his farm ranch, on his horse ranch in New Jersey, where he trains horses and riders in the, I guess you'd call it the art of dressage, a form of horseback riding. It has an Olympic appeal. Michael Barisone was himself an Olympic dressage rider, a horse rider in the art of dressage, however you would term that kind of thing. That's when he was younger. Now he owns a couple of horse ranches where he teaches other people the art of dressage, horses and riders, the art of dressage. One of those horse ranches was in Florida. That's not important for this case. The other is in New Jersey, where chaos ensued. So Michael Barisone agreed to take on board as a student one Lauren Kanarek. She was some 40 years old at the time, 41 years old, I believe, at the time of these events. She was a horse person interested in doing Olympic level dressage. Came to Michael Barisone. He invited her to live on his ranch and be instructed by him. Of course, when she did that, she was a tenant. Their relationship would prove rather toxic, and when he tried to get rid of her, or he asked her to leave, she would refuse. Lauren Kanarek would bring her boyfriend with her to live with her on the property, as well as her dog. And to say that the relationship between Lauren and her boyfriend on the one hand and Michael Barisone on the other was toxic is the understatement of the year, perhaps. This woman, Lauren Kanarek, gives all the indications to me of being a complete sociopath, a very vile and mean, bullying witch of a person. Michael Barisone comes across to me as someone who may well have been emotionally fragile at the start of this interaction, certainly appears to be emotionally broken now. And the escalation of the conflict between these two reached the point where finally Michael Barisone would pull a gun, shoot Lauren Kanarek twice in the chest. She would survive those injuries. She's just testifying in court over the last couple of days. We covered that in some detail, as well as shooting her at her boyfriend, Rob Goodwin. So those are the three people who were witnesses to this shooting event, to my knowledge. The defendant, Michael Barisone, the primary victim shot twice in the chest, Lauren Kanarek, and the boyfriend, Robert Goodwin, who was shot at. And Michael Barisone is now charged with 2 counts of attempted murder and presumably all the lesser included charges that would devolve from that. There are kind of 3 basic defenses that could be argued here by the defense and a fourth wish. 2 of those defenses, 2 of the 3 are perfect defenses, meaning they would excuse all criminal liability. One of those is the insanity defense, which would absolve the defendant of criminal liability, but would institutionalize him until his doctors felt he was safe to go back out in society. The second perfect defense would be the legal defense of self-defense, which would absolve the defendant completely of criminal liability and release him back into the world. Unfortunately for this defendant, both those perfect defenses don't seem to be getting much traction based on the evidence and testimony we've seen so far, which has largely consisted of the opening statements of the lawyers and the cross-examination of Lauren Kanarek herself. The insanity defense wouldn't really be contributed to by Lauren Kanarek. That will be the purview of the defense psychiatric and psychology experts, which they plan to present sometime next week when the defense presents their case in chief. But the legal defense of self-defense appears also to be getting no traction because I mean, you would expect that the cross-examination, the testimony, the hostile testimony of Lauren Kanarek, who was shot twice by this defendant, would be hostile to the theory of self-defense. But the defense isn't really even asking her the right questions to buttress a claim of self-defense at all. Once you've raised a prima facie case of self-defense, the state has to disprove it beyond a reasonable doubt. But you need to do something. It's not 0. And it needs to be something on each of the 5 elements of a claim of self-defense. These are those 5 elements of a claim of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. You can get a copy of what I just held up, that infographic, for free from our lawofselfdefense.com/elements webpage. It's cost nothing. We don't charge anything for this. It lists those 5 elements. and provides a brief description of each. If you don't understand these 5 elements, folks, you can't possibly understand self-defense law. These are the building blocks of any claim of self-defense made in any state in the United States, including New Jersey in this case. So I would urge you, when I talk about the 5 elements, innocence, imminence, proportionality, avoidance, and reasonableness, at the very least, if you do nothing else, please download this infographic, again at lawselfdefense.com/elements. And so far, I'm not seeing any traction from the defense on self-defense. Indeed, the defendant himself, the defense counsel for the defendant, on his opening statement, it was about 45 minutes long. He spent maybe 95% of that opening statement talking about factors having to do with the possible insanity defense and how mean Lauren Kanarek and her boyfriend, Robert Goodwin, have been to Michael Barisone, and maybe 5% talking about self-defense. So it's not at all clear to me that the defense here is really pursuing a legal defense of self-defense. Certainly, I've seen no evidence, not really much of a suggestion, that this defendant, Michael Barisone, was in fact facing a reasonably perceived imminent unlawful threat of death or serious bodily injury at the time he shot Lauren Kanarek and fired at her boyfriend, which is what is kind of the minimum required in order to have a substantive legal defense of self-defense. I just don't see it yet. So those were the perfect defenses: insanity defense, self-defense. If the jury buys them, it's an acquittal, 0 criminal liability. Although insanity defense doesn't just free you, you are institutionalized until your doctors say you're safe for society. There is an alternative defense, an imperfect defense, as opposed to a perfect defense. And there's a variety of ways of getting to this. In effect, the imperfect defense would mitigate what would have been an attempted murder conviction to an attempted manslaughter conviction. And one way to get that mitigation would be by arguing the doctrine of imperfect self-defense. Imperfect self-defense is recognized under New Jersey law. You won't find it in statute, but it's reflected in New Jersey case law, appellate court decisions, which is just as valid law as statutory law. And essentially, it holds that where a defendant had a genuine, subjective, good faith belief in the need to act in self-defense, but that belief was objectively unreasonable, you can't have perfect self-defense. You can't have an acquittal, because objective reasonableness is a condition of perfect self-defense. So if that's missing, you don't have perfect self-defense. You're missing a required component. But if you had a subjective, genuine, good faith belief in the need to act in self-defense, and it was merely unreasonable, you do lose perfect self-defense, but you can still qualify for imperfect self-defense, which wouldn't lead to an acquittal, but would mitigate murder down to manslaughter, or in this case, attempted murder down to attempted manslaughter. Another path to get to manslaughter would simply be diminished capacity. And this may well be why the defense is talking up so much about how evil Lauren Kanarek and her boyfriend, Robert Goodwin, were to this defendant. And that basically the argument would be through their intentional efforts, they had psychologically incapacitated this defendant. They drove him mad. And it's because of that conduct that he had a diminished capacity to reason and therefore could not form the intent to kill required for murder. Instead, the diminished capacity should mitigate murder to manslaughter, or again, in this case, attempted murder to attempted manslaughter. And this kind of diminished capacity is a common path to manslaughter. Usually in manslaughter, we speak of it in terms of what's called sufficient provocation. Often the classic example is someone comes home and finds their spouse in bed with a lover and shoots both the spouse and the lover. Often the law will hold that, well, that wasn't an intentional killing because there was sufficient provocation to diminish the capacity to form the intent for murder. Doesn't mean we'll let that killer go, but we'll hold them accountable for manslaughter rather than murder. And finally, we have just the wish, the hoped for wish, and that is if the defense can paint Lauren Kanarek and her boyfriend Robert Goodwin as being sufficiently vile that the jury will despise them so much that they'll have sympathy for this apparently deranged defendant sitting at the defense table. You'll see as we watch the video. I mean, he certainly comes across as crazy, rocking, grimacing, twisting his head around. I mean, you'll see by his demeanor when we show you the video that simply out of sympathy, they would choose either to acquit the defendant or more likely come to some kind of compromise verdict that was a lesser degree of offense than murder, probably manslaughter. Now, that's not really a legal argument. It's just an emotional argument, but sometimes emotional arguments work for a jury. So that's kind of the background of the case, the legal things we're looking for. So we're looking for we looked for it from Lauren Kanarek when we were watching her cross-examination, and we'll be looking for it for Robert Goodwin. Obviously, we would expect them to lie about any defenses, but at least the defense should be asking questions relevant to the possible legal defenses, not insanity, because again, the psychiatrist and psychologist called by the defense will speak to that, but to self-defense. Did you attack our defendant, our client, before he shot you? I mean, that's the critical issue here. The defendant, Michael Barisone, was beat up in this event, but the evidence appears to suggest that he was beaten after he shot them and shot at them. He was bitten by the couple's dog, but again, the evidence suggests he was bitten after he fired the shots. If he wants to use that beating as the imminent threat against which he was defending himself with a gun, it would have to have occurred or been imminently threatened before he fired the shots. If it occurred afterwards, it could not have justified his use of deadly defensive force. And frankly, to the extent that the Lauren Kanarek attacked him with a phone, which she testified to on cross-examination, she looks to me to weigh about 105 pounds, and she attacked him with a cell phone. That's not going to be a deadly force attack against a grown male that would justify the use of deadly defensive force. So there needs to be something more than that, and I'm not seeing the defense elicit that kind of testimony yet, not even asking the right questions to elicit that kind of testimony. So that's kind of where things stand after the several hours of cross-examination of Lauren Kanarek, where frankly, she ran circles around the defense counsel, who does not appear to be proficient, would be too strong a word to describe this attorney. I mean, he's just bad. He's certainly bad at cross-examination. He frequently asks compound questions, which lead to loosey-goosey answers, or people just don't understand the questions. Even the judge doesn't understand the questions. He tries to read documents into the record as if he were providing testimony. That's not allowed. Solicit hearsay evidence. And when he's called on these things, sometimes by the state when they object, sometimes by the judge saying, "What are you doing?" The defense counsel appears stunned, like he doesn't know this kind of stuff is not allowed. Now, he's an older gentleman. One might guess he's been at this a while. Someone this morning in the comments posted that he was previously an assistant U.S. attorney, a federal district attorney, basically, which I would find surprising by his demeanor. But in fairness, a lot of prosecutors have a pretty easy go of it. I mean, the people they're prosecuting are mostly criminals. They get to choose who they take to trial. Often it's a cakewalk compared to what the defense has to do in defending those people. He may just not have much experience, but based on, and I don't know anything about this defense counsel at all, except what I've seen from his conduct in court. And from what I've seen, this guy ought not be in court. He ought not be a trial attorney because he's not good at it. And especially at these stakes, an attempted murder trial where the clients, the defendants, the rest of his life is at stake. Not good. It's an ugly performance. Probably not constitutionally defective, but far below the threshold I would want for anybody. So that's an unfortunate circumstance for this defendant. All right, so that's kind of where we are. So we're going to jump into a video of the cross-examination of the boyfriend now, Robert Goodwin. And, it's going to be the same defense lawyer doing the cross again. I don't have high hopes, but I've heard that the testimony of the boyfriend is at least entertaining, perhaps in some respects contradictory to Lauren Kanarek's testimony, which would at least be interesting. And for those of you who hang until the end, so this morning when I was covering Lauren Kanarek's testimony, I had mentioned in passing that I had video of an event that occurred to me personally about a year ago when I was on a motorcycle trip out to Utah from my home in the Denver area. And I had stopped overnight in Durango, Colorado at the Strader Hotel, which is one of the historic Old Western hotels. It still has an Old Western style saloon in the basement, saloon restaurant. And I planned to stay there overnight, did stay there overnight. And I went down to the bar / restaurant / saloon in the basement to have dinner, where I was actually the victim of a simple battery by an old drunk lady. And I had promised video of that vicious drunk old lady assaulting me, battering me in that restaurant. and I wasn't able to actually come up with the video this morning. I boomered it. I thought I had it, but I had the wrong file. Well, I found it. So now I have the video of the old drunk lady battering your favorite self-defense attorney, Andrew Branca, in an Old West saloon in Durango, Colorado. So for those of you who hang in to the end, which shouldn't be too long, I think it's only an hour, a little over an hour of cross of the boyfriend. For those of you who hang in until the end, I will share that video of your favorite attorney just trying to eat his steak, being accosted and finally, brutally battered by this old drunk lady in a Western saloon. So that's the bait to stay to the end for those who do that. In the meantime, I'll play my little intro video here, do my little introductory plugs for our sponsor and our upcoming Hard to Convict webinars, and then we'll jump right into the video. So with your permission, here we go with the introductory video. All right, and I am back. So today's content is sponsored by, I guess I should have this. It would be nice if there was a better way to load this up. It's sponsored by CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members' legal expenses if the member is involved in a use of force event, and those expenses start big and get bigger fast, folks. If all you do is make an aggressor aware that you have a gun for the purpose of changing their behavior, which is what we're doing when we're saying, stop, I have a gun, I'm prepared to defend myself, you've checked all the boxes for a criminal charge of aggravated assault with a deadly weapon, which is good for 10 to 20 years in prison in most states, that you now have to justify as self-defense. And when you retain a lawyer for that charge, you'll be looking at a retainer of $30,000 to $50,000 for pre-trial work. Doesn't cover the trial. If you've killed somebody in what you believe is self-defense, it's easy to burn through $200,000 pre-trial before you get to trial. So if you don't have that kind of money stuffed in a mattress, just in case you've been compelled to defend yourself or your family against criminal predation, it can be helpful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depends on it, because it really does. And by the way, CCW Safe brings a lot more to the party than money. They also have a great legal and investigative team that arrives on the scene to serve you. Remember, the police are largely serving the prosecutor. So this investigative team, with their national trial counsel, Don West, one of the George Zimmerman lawyers, a world-class criminal defense lawyer, is there to make sure you're getting justice, your exculpatory evidence is being preserved, things are not being overlooked, video, surveillance camera footage that would be favorable to you is captured, exculpatory witnesses are captured, all that stuff. And that can make all the difference, folks, as you might imagine. Now, I've looked at all the companies that offer this kind of service, as you might imagine, and I found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member. Whether they're the best fit for you is something only you can decide, but I do urge you to take a look at what they have to offer at lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can get 10% off your first year of membership with the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10 at that URL, lawofselfdefense.com/CCW Safe. And also, I'd like to mention, we have a series of webinars that we've scheduled, 100% free webinars. We're calling these our Hard to Convict webinars. These are webinars in which we will bust a variety of self-defense law myths, things people believe, but if they followed, would lead them directly to a trial, conviction, and prison sentence. These are dangerous to your liberty, and we're going to bust these self-defense law myths for you for free in this series of webinars. Now, they're all the same, the webinars. You don't need to attend more than one. In fact, I would prefer that you didn't, because we have limited seats for each of these. So we set up several so you could pick a date and time convenient to you. We have 5 of these coming up, 5 scheduled throughout the month of April. They're free, 100% free. We don't charge a penny, and they'll be an hour or 2 in length. But there is a limit of 100 seats each. And I checked just before I went live here today, and 233 of those 500 seats are taken. Half. And I've only been talking about it for 2 days. So the seats are going fast, folks. So if attending one of our Hard to Convict, 100% free, Hard to Convict webinars is of interest to you, I would encourage you to sign up sooner rather than later at lawofselfdefense.com/hard to convict. Easy enough to remember. And hopefully I'll see a bunch of you there. That would be great. All right. I saw some of the comments ask, what number? Is this the first video on this case? It's not the first video on this case that I've done. I've done at least, I think, 3 on the cross-examination of Lauren Kanarek. And then I also did one on the opening statements of the state and of the defense. So that would be 4 altogether. This is the first video analysis I've done of the boyfriend's testimony. So the first part of the boyfriend's testimony we'll see here, he actually gave yesterday. So I'm a day behind in that respect. He continued his testimony this morning, and I think I'll catch up to that testimony this morning in this same show. So we should get through all the boyfriend's testimony, both what he did yesterday afternoon and what he did this morning here. That at least is our goal. Let's see. I should mention also this morning, we finally broke through 30,000 subscribers. Thank you all very much. I can't tell you how much I appreciate it. We're currently at 30,042 subscribers, and I'm extremely grateful for that. But just because we hit 30 doesn't mean we don't want 100. So please smash that subscribe button. You need to subscribe to comment anyway, so you'll want to do that. Hit the bell so you make sure you get notifications. YouTube is terrible about that when it comes to channels they don't like this channel, but nevertheless, you stand a better chance than not if you hit that bell, choose all notifications. If you could hit that thumbs up, like button, and leave a comment in the comment section, even if the comment is just your city and state, that helps fool the YouTube algorithm into sharing our content more broadly. And if you hate YouTube, we also do broadcasts on Rumble. And for our Law Self-Defense members, we also stream live at the same time on your Law Self-Defense member dashboard. In terms of answering questions, I'm happy to answer any question that anybody would want to pose. If you're a Law Self-Defense member, please post it on your member dashboard because those get 100% absolute priority. I'll answer every one of those, I promise. If you're watching on YouTube, it needs to be a super chat question. Sorry, but that's the only way to filter them out from the hundreds of other questions, comments that are in the chat. It's impossible for me to find it. Yeah, I don't know why YouTube doesn't like me. All I do is legal analysis, but they routinely demonetize me for the smallest of reasons, even just nonsense reasons. I don't know why. That's just the way they are. We also live stream on Rumble. If you're watching on Rumble, welcome. I don't tend to look at the Rumble comments or questions yet. I still have to work up to that level of social media expertise, but it's available there as an option for viewing at least. Okay, so let me pull this up first. This is, let me go over here. I'll pull up my super chat window so I can, every time there's whenever there's a pause, looks like that's still up to date. I'm pausing the action. I might tackle a question or two. Let me pull up my member dashboard here so I can capture those as well. Hopefully that's streaming correctly. Well, I don't know for sure that it is. Let me see. It's always a bit of a crapshoot, folks, when it comes to the live streaming to various platforms at the same time. You've got yourself a use of force lawyer here, not an IT expert, but let's see. Well, I can't really tell if it's working or not, folks, but I guess we'll see what happens. So with that out of the way, let me pull up the first part. Let's see. The first part of this cross-examination of Lauren Kanarek's boyfriend and see what he has to see. Now, again, Lauren Kanarek came to me across to me as a complete sociopath, a vile person who had no hesitation in conceding that she had written on social media the most horrible things about her host, Michael Barisone, that she desired to destroy his career, his reputation, his emotional state, his mental state, just horrible, bullying, torturous conduct, but none of which is justification for being shot twice in the chest by Michael Barisone. We'll have to see what kind of man dates a woman like that. That would be Robert Goodwin. So let's see what kind of fellow Robert Goodwin turns out to be. Let's see. First, it looks like there was some discussion among the between the judge and the lawyers before the jury was brought in. Okay, so the judge here is now he stood up. The jury must be coming in. By the way, you'll see this judge kind of body check this defense lawyer repeatedly. At least we did this morning during the cross-examination of Lauren Kanarek. And that's because this defense lawyer's got it coming. I mean, he's asking confusing questions. He's misreading language from transcripts, which, of course, you misread the words, it gives it a different meaning. He's just not very good at his job, and he's often asking questions in a manner that's outside the proper form for cross-examination. Maybe either is unintentionally or intentionally misleading the jury in terms of presenting evidence to them. And so the judge repeatedly holds him in check. This is not the judge being biased or mean to the defense. This is the judge doing the judge's job. I've heard that at Law and Crime, which is a hypothetical channel I've heard about on the internet that I've never watched, but I've heard there that people are going crazy about how quote-unquote biased this judge is. I don't see any bias here. I see a judge being compelled to deal with a not very good attorney. And he's doing the best he can, the judge, in achieving that. Okay. Let's max that out. Hit play, and here we go, folks. Okay, I'll skip ahead. Man, they're waiting a long time.
Ladies and gentlemen, we were working on a slight technical issue during the break, but we have it figured out. One other matter was brought to my attention. During the testimony of Mr. Goodwin, he used a laser pointer up on one of the photographs.
All right, I want to skip this. So they had just finished with the direct of the boyfriend, and apparently he was using a laser pointer that wasn't displaying correctly on whatever he was pointing it at. So the judge makes him do that part of the direct here again. It only takes a couple minutes, but it's part of the direct, not part of the cross. So I'm just going to, and it didn't seem very important. So I'm going to go ahead and skip that part here. That's it right there. And here, the defense is standing up. I think the defense is standing up to start cross-examination. So here we go.
Around here. You meet Barissone in 2018, correct?
Either beginning of 2018, end of 2017. I forgot what month we went down to Florida.
Okay, and you made reference to a clinic that Lauren was.
So here's the not very good defense
I don't know
attorney on the left.
was,
There's Michael Barisone
training
on the right,
thing.
going through his
Suffice it to
various
say that
facial gestures and appearing
discussions
kind of
between
crazy.
them, she agreed to come and train with Michael Barisone, correct?
That's correct.
Based on what you
And the witness
knew,
here is Robert Goodwin. He's the
Would you agree
boyfriend
with
of
me
Lauren
that
Kanarek.
was a
Kanarek was shot
huge
twice in the
step
chest
up
by Michael
from her
Barisone.
previous
Michael Barisone
training
also
with
shot at
regards
the
to
boyfriend,
the,
but did not hit him.
experience
Those
in
two
the
victims are the
facility.
victims for the 2 counts of
So we
attempted
made the
murder.
leap to change our lives and go up there and train with Michael.
Now, when you first went up there in 2019,
That's Robert Goodwin.
How many horses did Lauren have at that time at that facility?
Referring to when we went to the Florida, when we first met Michael.
Yes.
So a couple things I'll point out here. One is this defense attorney likes to ask questions about things that have nothing to do with either the legal charges or the legal defenses in this case, like the number of horses that Lauren Kanarek had at the farm. Now, it may be that Lauren Kanarek brought more horses than she was supposed to, or was otherwise attempting to take advantage or stress Michael Barisone, Barissone, but none of that would justify him shooting her. It's maybe bad behavior by her, but it's not a justification for firing 2 rounds into her chest and a round at this fellow. The other thing is this defense attorney has a tendency to ask questions that are arguably very ambiguous, unclear, compound. And so repeatedly the witnesses are like, are you asking me this or are you asking me that? And even the judge sometimes interrupts and says, what is the question here exactly? There's 2 problems with that. One is it's not effective in building your narrative of defense for your client, but it also opens the door for all these witnesses to give ambiguous, confusing replies. You're giving them an opportunity for you not to be effective. And that's not good when you're dealing with the state's witnesses on cross-examination as the defense. You need to drive them down a particular path to the extent you can. Now, you might ask the right questions and you're still confounded in moving down that path, but it's certainly not going to happen if you're asking bad questions, which is what this defense counsel has a propensity to do.
She had 2 horses, correct?
Yeah, I guess it was 2. I wasn't sure if it was just Evie. It might have been Evie and Fritz.
Okay, and then after the winter, you came up in 2018 to the New Jersey facility, correct?
Yes.
Now, you were living on the main floor of the farmhouse at that time, correct?
Correct.
Okay, and
Correct. Little B Ivory there.
your understanding of the deal was that Lauren would pay $25 per horse, $2,500 per horse to have those horses boarded there and trained. And there was also an additional benefit to you and Lauren that he would provide living accommodations, correct?
That's correct.
Okay. Now, who negotiated that deal? Was it Lauren or Lauren's father?
I'm not sure.
But as far as you're concerned, and correct me if I'm wrong,
This is also a propensity of this defense counsel. He keeps asking questions he doesn't know the answers to, which is crazy. You need to know what the answer, at least what the answer is supposed to be. I mean, if the witness then gives you a different answer, you can impeach the witness with proof of the correct answer. But to ask questions, isn't it true that A, and the witness can just say, no? Well, where the hell do you go from there? And he just did it again here. Isn't it true that the deal with, who negotiated that arrangement? Boyfriend goes, I don't know. So what was the point of that? Where does that get you? First of all, does it matter? I don't think it does matter who negotiated the arrangement, whatever the arrangement might have been or who did it. It's not relevant to this shooting. But in any case, it's particularly pointless if the witness you're asking the question of can simply say, I don't know. It's pointless and poor form.
you didn't pay any additional rent for living accommodations, correct?
We wouldn't have went up there if we had to pay for it. It wouldn't have been feasible if we had to pay for rent anywhere. Either on.
Okay, this witness is not answering the question. This is cross. I mean, in a model cross, you can ask leading questions and you're supposed to get yes or no answers out of the witness. When this lawyer asks, you weren't paying any extra money for housing, were you? The answer is no. If they weren't, the answer is no. The answer is not some extended narrative about why they weren't paying. If they want that narrative to be, if that witness wants that explanation, it's up to the state to pull that from them or request that of them during redirect. The defense counsel is not supposed to be allowing this hostile witness, hostile to his client's interest, to be giving a narrative answer to cross-examination questions.
On the farm or off the farm.
Okay. And were you working at the time?
I don't believe so. In New Jersey?
In New Jersey, when you came up here, you didn't have a another?
No,
job?
when we came down to New Jersey, I was not working at the time.
And would you agree with me that when the living arrangement situation was made, you originally was not included in that deal? So
You originally was
sorry,
not
Gary.
included.
were you aware that when the living arrangements were made for Lauren, that you were not originally included in that deal?
No, that is not true. Lauren would not have come down without me, or come up, sorry.
Okay, so
Again, unless
come
this
up with
lawyer
Lauren,
has evidence to
what
contradict
is
that
your
answer,
job
what was the
under
point of asking the
Rocky
question?
in the summer of
What's the point of the
2018?
question? What difference does it make?
Summer of 2018, I helped Lauren with the horses. Summer of 2018, yeah, I helped Lauren with the horses.
And what do you specifically mean by that? Is that like a 9 to 5 type job, or
No, not at all.
what is
I get to spend time with horses and animals that I love. Get to spend time with Lauren, spend time with my dog. So, I mean,
were you getting paid to do that?
was I getting paid?
Someone in the comments says, I heard this defense attorney was big bucks.
I guess so, yeah, in a sense.
My sense is this defense attorney is
Yes,
more
so
like
in a sense.
good luck.
Was Lauren paying you money?
Lauren gave me money to pay my bills. That is correct.
So you're basically living for free in the farmhouse, correct?
I mean, this is not a legal argument.
What do you
None of
mean,
this is
babe?
relevant. I mean, the
I was
defense is
li-
trying to
we were living
characterize
in the
this guy
house
as
for
kind of a
free.
deadbeat,
I mean,
living
not
off
for free.
Lauren
The horses
Kanarek's
weren't
money,
there
which
for
apparently was really her daddy's money.
the $5,000.
So it's kind of
we
a,
wouldn't be
I don't
living
know,
in the
it's supposed to be a
farmhouse,
shameful
but- Yeah, so.
living arrangement somehow.
So
But okay, so what if it is?
were there some problems in 2018 with Lauren and the staff, to your knowledge?
I don't recall.
Did she always show up on time to her riding lessons?
So many pronouns.
I mean,
Who?
no, I highly doubt anybody ever shows up everywhere on time. I don't understand the question.
Okay.
Is that
Was
a
Michael
question?
Barisone training her and her horses in the summer of 2018?
It was more Justin Harding was training. Michael was in the background and, gave tips and advice and, he was like overseeing and adding input along the way.
And that's basically pretty much what Lauren expected with regards to the arrangement that she made, correct?
Objection.
To your knowledge.
Well, it's still, that doesn't, it still calls for a hearsay answer.
So
Sustained.
Remember what trial was it? Was it the Curtis Reeves trial where the defense kept getting away with answering questions that went to that were hearsay, looking for hearsay responses, and the state would object, and the judge would uphold the objection, and the defense would respond by saying, "Would you agree or disagree?" and then repeat the same question and be allowed to solicit the hearsay. I mean, it was unbelievable. And this judge is clearly not allowing that. This defense attorney is trying to do much the same thing, but just putting some magic words in front of the impermissible question and imagining that makes the impermissible question permissible. It doesn't work that way.
And ask another question.
in the very beginning, in 2008.
Everything I ever hear about law and chat just
Justin
makes me
Harding
think
was
less of them.
training
If it's true, they said
Lauren
this defense
and her
attorney, he
horses
may be expensive. I don't know.
Michael
I mean, some
Barisone
attorneys have a good
overseeing the
grift.
operation,
Uh,
correct?
But if this is one of the
That's
best
correct.
attorneys in New Jersey, New
And
Jersey's got a
Justin
serious
Harding
problem.
continued to train throughout 2018 before you guys went back down to Florida.
So he did, and I see where this is going. So,
This simply is
Michael
not an attorney
wanted to
who
get to
strikes
know
me
the
as
horses
having
before he
trial
got on.
experience.
so if we're trying to get to, was Michael the planned trainer?
Yeah,
Yes, he
I mean,
was.
just
He was
look at the
supposed to be
defense attorneys we've
eventually
seen over the last
the
6 months,
main
and just in the
trainer of
high-profile
Lauren
cases
horses.
I've covered. Earl Gray,
Okay?
Uh,
And,
Corey Trafficy, even the lawyers in the Curtis Reeves trial, while their opening and closing statements were horrible,
After
their
the
cross
summer-
was very good.
everybody goes to the facility in Florida because it's cold and snowy up here, correct?
In the winter, correct?
Okay. Now, when you went to Florida.
No, I don't think
did
this
he
judge is
provide
biased.
Living accommodation.
I've
Well,
seen
in
no
Florida,
evidence of that
no.
at all.
Where
Does he
did you
sometimes
guys stay?
chastise this defense attorney? Yeah, he does for
He's
sure,
been,
but the defense
Michael.
attorneys earned it.
Were you still paying the $2,500 that you were paying
No, we paid more.
How much were you paying in Florida?
Yeah, I didn't watch the
Florida's
Dr.
more
Hustle
expensive,
trial,
we
so I
paid,
can't comment on that.
$3,000 a horse, I believe.
And based on your knowledge,
Eric
that's a
Nelson for the
number
Derek
per
Chauvin
horse
trial. I
in
thought
these types of
Eric was pretty
facilities,
good
correct?
during the course
I
of the
don't
trial.
know.
I thought his closing argument was awful.
Now, the prosecutor brought up your drug use.
And he wasn't great on voir dire,
You
Eric Nelson, either.
agree
I'm not sure there's
that
much he could have
during
done
the
about that, though.
time that Lauren was being trained by Michael Barisone.
Judge, can we be heard at sidebar?
All right, the objection is overruled. I will allow limited questioning, Mr. Barissone, for the reasons stated at sidebar.
Mr. Goodwin. The prosecutor
That was a
brought
weird
up
cut.
your
Was that
story.
edited by Law and Crime?
You indicated that you never did drugs at the facility, correct?
That is correct.
It is a fact that you were doing drugs during the time that you and Lauren Kanarek were using Barissone's facility off of the facility.
I did state I had a few relapses throughout that time.
So, all right. So they had found, there's evidence of Suboxone found in the garbage of these people, Lauren Kanarek and the boyfriend, Rob Goodwin, which they'd only be making use of if they were at least under treatment for drug use, opioid drug use. And now he's admitting, Robert Goodwin, that he had some relapses during this period. For any of you who've known drug addicts, it's difficult to imagine a drug addict would somehow be disciplined enough to only use their opioids off the property, but not where they actually sleep at night. I don't believe it. I guess he's been compelled to confess or concede that he's a drug user, or at least was at the time, because of the Suboxone found in the garbage. But this is not really credible. But it doesn't really matter. I mean, it's in no way being tied to any of the legal defenses here, either insanity on the part of Barissone, or self-defense on the part of Barissone, or even imperfect self-defense. It goes to, maybe you think drug users are bad people, so maybe you're trying to taint this couple, Lauren Kanarek and Robert Goodwin, in the eyes of the jury, and certainly there's plenty about them to dislike. But that's not a legal defense.
So while Barissone was training Lauren Kanarek and you were living in his home, you had a few relapses, correct?
Right, but with the specification, not on the farm.
Not on the farm.
Michael Barisone or any of the staff
Just
never.
hold on.
That's
Just
not an
the
answer to the question.
No
Okay.
question.
The question was, off of the facility, while Lauren was being trained and you were living in Barissone's house,
I mean, I'll feel
You were
terrible
doing
about some of my
drugs,
comments if it
correct?
turns out this
Had a
lawyer, this
relapse
defense
during
counsel,
that
is
time.
suffering some kind of
and we're talking
dementia
about crack.
and was world class until
I
a
think
couple of
this
years
was
ago, and it's
beyond
been
the scope
downhill
of
ever
what
since
you
through
were
no
saying.
fault of his
No,
own.
it's,
But the comments remain true.
No,
I'm
not
only
the
basing my
specific.
comments.
that's bad conduct of it. It was used only for impeachment or to clarify his earlier answers. That objection sustained.
Yeah, he's trying to say you're a druggie, aren't you? How's that relevant? So my comments on his defense counsel are not based on his history. I don't know anything about his history. It's
Now-
only on his performance that I see
I'm
here.
going to move on. When you came back in 2019, there was a flood, and you saw the evidence of that, correct?
Correct.
And basically, the house needed a lot of renovations, correct?
Correct.
Now, when you came back up from Florida in 2019, Lauren decided to bring more horses to the facility to board and train, correct?
That's correct.
And an agreement was made with you that she would pay no more money to board and train those horses if you did a total and complete renovation of the house, correct?
Again, he's asking questions in a way that makes it easy for the witness to deny by being too detailed and too specific. This whole total and complete renovation of the house, were those words really used? I think there would be a written document if there were. This witness is just going to say, no, I mean, I offered to help with the renovation, but what's total and complete mean? No, I deny that. I mean, you're making it easy for him to say no. And where do you go from there?
No, that would be a very big deal. I mean, if I did the renovations, do I get to board and train for the rest of my life?
When you
No,
say for the rest of the life, you brought 2 additional horses up, correct?
We brought one. One she bought from Michael,
Correct?
and the other one was the retired one, which Michael was telling us for, a couple of months to bring up.
She now had 3. She was talking about bringing a 4th, correct?
Yes, I talked about bringing a 4th.
And even a 5th, correct? Having a 5th horse,
I'm
But
sorry.
all you did was
the
talk
third one
about it.
was
What difference
purchased
does it make?
From Michael.
okay, irrespective of where she got it from.
Well, she didn't bring it there is what I'm trying to
Okay.
say.
So irrespective of where she got it from, she would basically be boarding up to 5 horses without paying for 3 of them, correct?
I was under the impression that the horse she purchased was free to live there for the rest of its life under
Well, again,
training.
you don't have any personal knowledge of that.
Then why are
correct?
you asking him?
But you're asking, Mr. Blinkus, that's the problem. I don't know what the source of his knowledge is. Is it hearsay knowledge? Was he part of negotiations?
Okay.
You gotta clarify this so
Understood.
we know
Understood.
the
You weren't a-
reliability.
Sorry,
Go
you
ahead.
weren't a part of those
I mean, I would
negotiations,
expect
correct?
more out of
So you have no idea what deal was
an
made,
attorney
correct?
first year after the bar than this.
Other than what someone else told you, correct?
With regards to the horses in Lauren, no.
Okay. So my point is, Lauren Kanarek had basically entered into an agreement where she was going to board 5 horses and only pay for 2, correct?
Well, they just said he wasn't part of the negotiations. How can he answer that question?
I'll withdraw that.
Just withdraw, move on.
Okay.
Right. So the jury, there are standards of quality for evidence that can be presented to the jury. Witnesses are supposed to be testifying from their personal knowledge, not just speculating or guessing or repeating words that were said by other people, hearsay. If you want the words of the other people introduced as evidence to the jury, you have to bring those other people into court to say those words, to testify about those words, because that's the only way the jury can evaluate the credibility of those statements, by having that witness, the direct witness, in front of them, hearing them, seeing them, evaluating their demeanor, making a determination of credibility. That's why hearsay is not generally allowed unless it meets one of many, admittedly, exceptions to the general hearsay prohibition. You can't be asking witnesses questions about which they have no direct knowledge, let them guess and answer, and have that be presented to the jury as substantive evidence in the case. And that's why the judge is interrupting this defense counsel, because that's what he's doing. It would be like if you saw somebody making a giant vat of dough in a bakery and they were pouring something weird into the mix. You'd say, well, that's not right. You can't do that. Instead of 5 pounds of sugar, they were pouring 5 pounds of salt in. That's not how this is done. And that's the trouble with this defense counsel. He keeps doing things like this that are simply impermissible. I mean, under very basic rules of evidence that every lawyer ought to know. And not just know, but on a visceral level. You don't tie your shoelaces together to the other shoe. It's amazing to me that he keeps doing this, despite having been corrected by the judge repeatedly. And he just looks confused when he's called on this. I mean, listen, sometimes if you're a lawyer, you skirt the edge. You'll see, maybe I'll get away with it. Maybe the other side won't object. Maybe the judge will let it go. Maybe I'll get that evidence in front of the jury. Just to influence them. And then if you get caught, you take the hit or you provide some kind of explanation. What you don't do is look like a stunned deer that has no idea why you're being stopped. And if people at, I don't know what people at Law of Crime are doing. I don't do this. I see here people commenting that they think when the judge does this, the judge is being biased or rude or mean to the defense. He's just doing his job, folks. And frankly, in a much nicer way than he needs to. I mean, Judge Borkowski from the Edgecombe trial would, man, they'd be going to chambers a lot, and he would be very unhappy.
You personally agreed to do construction work as a trade-off for whatever deal these people made, correct?
I had a conversation with Michael saying that because the water flooded the apartment and I was already working on the barn, that, we could trade work for the cost of the 2 additional horses, which would be Symphony and Rose, trade the work for that. And if there was any extra work, that it would be paid in cash.
Okay, and when you say extra work paid in cash, the work you agreed to do was work on the farmhouse, correct, at that point?
Yeah, I mean, that was where the main focus was, yes.
Okay, and will you agree with me that at the time of the shooting, there's a hell of a lot of work that still needs to be done at that facility?
That's correct.
The judge has a fundamental responsibility to make sure the rules of evidence are followed in his courtroom. And he's not going to allow the jury to get evidence that is not appropriate for them to hear. Speculation, hearsay, imagination, false representation of what is actually written in a transcript. The judge is not only under no obligation to let that go, even if the state doesn't object, he's got a duty to maintain the integrity of the evidence being offered. Now, it's not his job to make any kind of statement of the credibility of that evidence or the weight of that evidence. That's for the jury to decide. But before the jury gets evidence in the first place, it has to meet some minimal quality evidentiary threshold. And if it doesn't, it's the judge's job to exclude that evidence, to not permit it.
There's no insulation or sheetrock in the kitchen, which we saw in pictures, correct?
I was working in the basement at the time.
Okay, but the basement wasn't finished either, correct?
That is correct.
The bathroom wasn't completed that we saw.
And by the way, we've all heard the expression, never interfere with an enemy in the process of destroying itself. The state doesn't need to object here because the defense is being so inept that the judge is compelled to intervene. And then the state doesn't have to put itself in a position where it's constantly objecting. If the defense were not being inept, it would be a different matter. But the defense is what's making all this possible and necessary.
The picture, correct?
Correct.
Okay, there were 2 rooms that we saw that were tiled, correct?
I mean, if there's a lot more work than tile, but yes.
Okay.
There was two rooms that were tiled, finished, painted.
Okay.
2
Now,
rooms that,
you didn't do that tile work, did you?
excuse me?
You didn't do the tile work in those 2 rooms, did you? Didn't Michael's friend do the tile work?
Nobody cares about any of
Is it
this.
your sworn testimony?
Michael's friend helped. Actually, Michael's employee, Mike McGreen, helped.
Okay, Mike
He is
McGrady.
not, no,
Well, did Michael help?
lay tile, no.
I mean, with other construction that was going on at the facility?
Who
At the
cares?
farmhouse or the barn?
First at the farmhouse.
At the farmhouse, no.
How about the barn?
At the barn, yes.
This Michael McGrady, what did he do in the basement area?
I mean, it's infuriating. It's like if you've ever had, well, I won't say a wife, but a girlfriend or a boyfriend who's telling a story about their day at work that involves 8 different people, and they refer to everybody using pronouns. So it's impossible for you to know. They know who they're talking about, but of course, you don't know what they're talking about because all the pronouns are the same. Well, that's what this defense attorney does. He talks about things happening at different locations in different buildings and doesn't clarify which building he's talking about, or different people doing different things and refers to them by pronouns. So nobody understands what the hell he's talking about, asking about. It's crazy.
Michael helped me tile pretty much, some of the floor.
Was he a helper? Did he do an equal part? What was the role of each other?
He was a helper. When he had free time, he would come down and lend me a hand, my tools, my materials that I picked up.
Okay.
He would give me a hand. It's easier to do tile with two people.
And you didn't show up every day and work a full day with regards to this construction at the farmhouse, did you?
No, not at all.
And you would show up when it was convenient for you, correct?
What difference does any of this make to the legal charges or the legal defenses? If he showed up and worked as a 9-to-5 job, or if he half-assed it, what difference does it make?
I would show up to do a slow, steady pace. If I did, let's say, 28 days of work, and the horse is going to cost, for Symphony, the only one there at that time, $2,500. Do I want to get ahead of myself? No. So I did a controlled pace. Michael also had a problem paying for the materials, to have the materials there at points in time.
Okay, so
All right, that was not an answer to any question, right? Why did this defense counsel not immediately stop this witness from continuing when he wants to add this narrative content to his answers that are not responsive to a question?
you basically worked at a pace where you felt your work was commensurate with the amount of money Lauren would have to pay to house these horses, correct?
I did not say that.
Do you think you're way ahead of Michael Barisone with regards to the construction of the farmhouse?
I think we had a good relationship, and I just wanted to keep busy.
I mean, these are questions. If this was a civil suit between Michael Barisone and these people, this guy, where he'd said, all right, I'll let you stay in this house, or I'll keep your horse, or whatever, in exchange for you doing work on the property, and they were not happy with each other in that arrangement, maybe because Michael Barisone felt this guy was half-assing it, and he wanted to get out of the arrangement or sue for damages, or these are questions you would ask in that civil suit that would be relevant there. Isn't it true you weren't working to the expectation of Michael Barisone? Maybe, okay. And maybe you should be held account to that. If there was a meeting of the minds about how rapidly the renovation work would go and he's half-assing it, sure, you got a complaint. I see zero relevance in this attempted murder trial, this criminal trial, for anything to do with this line of questioning.
I also like to work. Also, I did believe we were ahead, and there was a lot of work per, at this point, it's Symphony that's there. Symphony was there, I believe, for maybe 2 months or so. So, well, you say tile, sheetrock, insulation, framing of walls, rehanging of doors, painting, spackling. For one horse, 20, let's put it, 2 months, $2,500, $5,000. So I would say yes, I was ahead.
So you're not a licensed contractor, are you?
I am not.
You're not even supposed to be doing construction in New Jersey without a license. Are you aware of that?
I know that.
I'm gonna object.
And what's the relevance, Mr. Belinkus?
The value of his work as opposed to a license.
I think we've had enough of this area, Mr. Belinkus. Move on.
Yep. I have to be honest, this judge is cutting this defense a lot of slack with these long series of questions about things that have nothing to do with the criminal charges or the legal defenses. I mean, whether this guy's a licensed contractor, what's that got to do with Michael Barisone shooting Lauren Kanarek twice in the chest and shooting at this guy?
Well, you indicated what you thought Michael's personality was. You said bold, loud, funny, personable. And then you said sometimes angry. Do you recall saying that?
Yes.
Would that pretty much describe a lot of people?
I'm not sure.
And during the entire time that you saw Michael Barisone, you never saw him become violent, did you?
With people, no.
Until he shot
He
my
never
girlfriend.
threatened you, or you never saw him threaten Lauren Kanarek at any point in time in the entire period of time that you knew him, correct?
I don't believe so.
Now,
Generally
I'm here to
speaking,
talk
you'll
to
be
you
expected
about
to have a
certain,
license to do work
time
for another person
restrictions.
if you're being
When
paid for
did
that work. If you're helping a neighbor
Barisone's
do
staff
something, I don't think you'd need a license. But if they're paying you to do it,
turn
you're
against
supposed to have a
Lauren
license.
Kanarek?
A couple weeks prior to the shooting.
Was Lauren Kanarek having problems?
Especially a
with
rather
Justin
extensive
Hart?
renovation, which this was. This was not helping a neighbor
Yeah,
put up
we
a
were
mailbox.
unhappy with the way training with Evie was going.
Did Lauren Kanarek have problems with Mary Haskins?
She didn't want Mary Haskins as a trainer.
She didn't like Mary Haskins at all, correct?
Did you ask her?
Yeah, right.
Based on your observations.
Come on.
Was it obvious
He can't
to
testify
you
to someone
that there
else's
was a problem between
feelings about somebody.
Lauren Kanarek and Mary Haskins Gray?
I mean, I don't know if it was anything more than being catty.
Jealousy?
I have no clue.
He can't speak to her state of mind.
Strike that. Were you aware that Lauren Kanarek was pasting or posting derogatory Facebook posts on the internet talking about Michael Barisone
Again,
and Mary Haskins?
he's characterizing the Facebook post as derogatory. Maybe they were derogatory, but the lawyer doesn't get to characterize them as derogatory. You'd have to present those posts to the jury and let them come to that conclusion.
Right.
I may have heard something along the way, but I couldn't state what it was.
To be clear, you can characterize them as derogatory if you're doing opening statements or closing statements, because then the jury is told what you're saying is not evidence, but you're not supposed to be doing it in the trial proper.
And who did you hear this along the way from?
I don't remember.
Wasn't everybody talking about these posts at the facility the last 2 to 3 weeks prior to the incident?
I'm not sure. I could tell you that at least a week, maybe two. I don't think. No, about a week prior to the shooting, nobody really communicated with me at all.
And were you communicating with Lauren, like asking her what's going on, or why are these people acting this way? Did you have
But
any
I couldn't give you an accurate description over the last 2.5 years. I've heard, many different things. I can't tell you what our conversation was 2.5 years ago. So that's what I'm trying to get to.
Okay. Well, you testified on direct that at some point in time, there were time limits placed on when you can go to the stadium.
That's correct.
Okay. Those time limits were posted after Michael Barisone left his own home and was now living in the stable area, correct?
I do not recall the exact date of when those were posted. I know the police came up one.
Who knows what Barissone thinks about his
And,
attorney? I mean,
it's on record when
he
we
may
talked
not be in
about
any position to make an informed opinion of his
prior to
attorney.
that,
He may think his attorney's doing a good job getting chastised by the judge because, man, he's
You are
really
aware
pushing the
that
limits for my defense.
Michael Barisone left his house at some point, correct? correct?
I am.
And do you have any idea why someone, or specifically he left his house?
I have many ideas, and one could be they didn't want to live in a construction zone. Two,
This is all
animosity
speculation.
between everybody. You know,
The answer is no.
I didn't ask them. They didn't tell me.
I don't know why.
We saw the pictures of the main floor. Your apartment was right above that area, correct?
Yes.
And there was no insulation or sheetrock on the ceilings and numerous walls, correct?
Yeah, for those who may have come in late,
I believe mainly
if
in
you
the kitchen, maybe
joined
maybe
us
the bathroom.
this morning
On
when I was
that
covering the
100%.
cross of Lauren
yes,
Kanarek.
there was
I
a
mentioned I had
sheetrock,
video
some of the
of
walls
me
had-
personally,
yeah.
your favorite
And
use of
we
force attorney on
agree
the
with
internet,
you that because of
being
that,
physically battered by an old
there
drunk
wasn't any
woman
real
in Durango, Colorado
soundproofing
last May.
and you could
I tried
hear
to share that
things
video this morning, couldn't find it.
between
I have
living
found it.
areas.
So if you stay to the
Yeah,
end
there
of
is
today's show, I will share
Insulation and
the
sheetrock, you
video
could still
of
hear
the
things
old
prior-
drunk
prior to the
lady
damage, you could hear
attacking
things
yours
sometimes.
truly
Okay?
in a old West
After the
Saloon in
damage,
Durango, Colorado
it
last
got a
May.
lot worse.
I
Would
got
you
it.
agree?
I
We'll
imagine
share it.
So yes.
Did you and Lauren Kanarek have a lot of fights?
There's lots of
and
things that
yelling
the jury might be curious
arguments
about. That doesn't make it relevant.
while he was
That's one of the
living
reasons
below
that
you
a core function of a court is to act as a gatekeeper on what evidence and testimony is permitted.
on a regular basis?
Yeah, we argued. We argued a good deal.
Now, at some point, you decided to purchase cameras to try to protect yourself, correct?
I purchased camera because we were going to the show the next week.
And that's the only reason why
I
you
wanted to
purchased?
protect my property, correct.
When you say your property, you want to protect the.
I wanted to make sure nobody was coming into my house.
Okay. And on the 6th, someone did come into your house, correct? Ms. Cox?
If it was, Ms. Cox did come into my house at one day that week.
The judge could potentially have a duty to intervene if the defense counsel was being constitutionally ineffective. You have a U.S. constitutional right to effective assistance of counsel. But man, it's a low threshold to be constitutionally effective. There's been cases where lawyers fell asleep during the trial proceedings and were not found to be constitutionally ineffective. So you really have to suck. Merely being a bad lawyer or being inept is not sufficient by itself to be deemed constitutionally ineffective counsel. In any case, ineffective assistance of counsel is generally an appellate issue, not something that's actually hashed out at trial.
Okay, and that was captured on your cameras, correct?
That was, yes.
Okay, that was the day that the town came and did whatever they did, correct? The day that Ms. Cox.
So one of the funny theories I've heard is that perhaps Lauren Kanarek and Robert Goodwin had beaten Michael Barisone into unconsciousness and then took his gun and shot the boyfriend shot Lauren Kanarek himself. And then when Michael regained consciousness, he discovered that he was accused of shooting Lauren Kanarek, that the boyfriend would shoot Lauren Kanarek twice in the chest with a pistol to frame Michael Barisone. I'm waiting for this defense counsel to ask that question of the boyfriend. Isn't it true that you shot Lauren Kanarek? Because if he doesn't now, of course, you're going to get a lie in response if it's true, right? Obviously, this witness would lie about having done that. But if he doesn't even ask the question, there's nothing there.
Was bitten by your dog.
Oh, yes, actually, yes.
And you have your dog and Ms. Cox on that video, correct?
Yes, I had Miss Cox in my apartment.
So on the 6th, those cameras were working, correct?
For one day, I believe.
And recording, correct?
Recorded, yes. I don't know if they recorded throughout the day.
Now, you also purchased other surveillance equipment, correct?
More specific?
Recorders, tape recorders, so you can record private conversations.
I did purchase digital recorders.
How many?
2.
When did you purchase them?
So I see a comment here. Another theory is that Lauren Kanarek and the boyfriend Robert Goodwin stole the gun from the safe. So here's how it works in court, folks. If you want to put forth a theory, you need to have evidence to support that theory. You can't just imagineer a theory. If a theory, an argument, does not have an evidentiary foundation, it does not exist for legal purposes. So on the internet, it's fine in the comments for people to do things like, well, maybe they did this, or maybe they did that, or maybe they took it out of the safe. Where's the evidence? Where's any evidence that they even knew there was a safe, that they knew how to get in, that they broke into it, that the gun was in the safe? Any of that foundation that you would need to support that kind of hypothesis in a court of law. It's not just the internet there anymore, folks. That's why we have courts. That's why we have judges, to require that kind of evidentiary foundation. You're not allowed to make just any legal argument you want to throw up into the air in a court of law. There needs to be evidence to support that legal argument. And I've seen none to support any theory that they stole the gun from Michael Barisone's safe.
Somewhere around the beginning or the end of the, beginning of August, the end of the month prior.
That could have been a defense here, by the way. Some other dude did it.
Purchased them online.
The alibi defense. It wasn't
And
me.
at any point in time,
But this
did
defense
the
counsel never
prosecutor
mentioned
ask
that in
for
opening.
proof of
He's not
purchase?
denying that his
Did
client
he
fired the
discuss
shot.
this case with you?
I don't believe so.
Now, whose idea was?
Is there
it
any
to
chance
purchase
that
those
Barissone was
recorders?
assaulted before he fired the shots? Sure, there's a theoretical chance, and that
Will you
is
agree
what
with
would
me
need
that
to
they were
happen for him to have a
purchased for a
viable claim of
specific
self-defense,
reason?
either being attacked or imminently about to be attacked.
I mean, yes.
No evidence of that. Not
You had
even
discussions with
good
Lauren
questions on that.
and her father with regards to putting a tape recorder in certain places to record conversations, correct?
I don't recall the specifics.
Well, who was in charge of these recorders? You or Lauren?
I was.
You were the one that physically put the recorders in whatever place they were in, correct?
In her locker at the barn.
Is it your sworn testimony that the only place you ever recorded a conversation was from Lauren's locker?
The only place I placed the device is Lauren's locker.
And where else did you record conversations?
In my house, my truck, in my pocket.
Did you ever place one by a dumpster?
No.
Did you ever record conversations by a rock where the staff members would go and sit?
I believe I just, so the only place I placed one is in Lauren's locker.
So if I could play that audio.
Let me see that sidebar. We have a legal issue that we have to resolve, and it's close to 4:30, so this is one of those days you get to leave a little bit early today. All right, so we're going to stay. The lawyers and I will stay to resolve this issue, and we'll pick up again.
So interestingly enough, so that would be the wrap up of this cross of Robert Goodwin yesterday. So the testimony we've been watching was given yesterday. It's interesting. It looks like Law and Crime has begun editing these videos to cut out or maybe pausing the recording during the sidebars. I don't normally see them putting that kind of effort into this, frankly. Normally, we just have to sit through the sidebars or advance the video ourselves, but regardless. So that's the end of the day yesterday. So let's proceed now to the start of the cross-examination of Robert. Is it Goodwin or Goodman? I thought it was Goodman. But the Law and Crime has changed the name here. Regardless, the boyfriend, Robert, this morning, and that should wrap up his testimony. And this is, it looks to be about another hour, unfortunately. And then it will be, then it looks like there's a little bit of redirect at the end. I don't think I'll do the redirect because it's too predictable. It's not really, doesn't really inform us about the legal defenses here. Okay, so let me pull that up, close that. Again, while we have this pause between the videos, let me remind you, we are holding a series of absolutely free webinars. We're calling these our Hard to Convict webinars. We've got 5 of them scheduled over the course of the month of April. All 5 are the same. You would only want to attend one. We just have 5 so people can choose which one has the best date and time for them. These are webinars in which we will bust the most common and most dangerous self-defense law myths, things that people believe are true about self-defense law because they've read it on the internet or in a gun magazine, or the retired cop down the street told them, or the lawyer who did their house closing told them, or their gun buddy told them, and they're not true. In fact, not only they're not true, they're dangerous to your liberty. They're the kind of myths that, if followed, would very likely lead to a prosecution, conviction, and lengthy prison term. And we don't want that to happen to you. So we're going to hold these series of 1 to 2 hour absolutely free webinars, folks. They don't cost a penny. Are Hard to Convict webinars to help educate all of you on what the actual law of self-defense is. There's no charge, 100% free, but there is limited seating. So we have 100 seats per seminar so the 5 seminars, 500 seats. And before I started this afternoon's live show, I checked the numbers and we had 233 of those 500 seats already taken. I've only been talking about these webinars for 2 days, folks, and half of them are gone. So if you'd like to have a seat at one of our Hard to Convict webinars, I encourage you to sign up sooner rather than later. They're free, folks, at lawofselfdefense.com/hard to convict. Okay, let me pull up the next of these videos of the cross-examination of the boyfriend, Robert, whatever his last name is, Good something. So there's the judge, waiting for the judge to stand up. Okay, here we go. Here's the witness. And we are off to the races. Oh, let me check the super chats before I do that, and the Law Self-Defense members. So Beth, a Law Self-Defense member, thank you very much, Beth, at her member dashboard says, which judges out of the recent cases you have covered, in your opinion, understood the issues surrounding self-defense? Well, it's hard to say because there were defects in many of these trials, but the legal defects tended not to be on self-defense per se. For example, in the Kim Potter trial, that's the taser trial. The defect was the judge allowing the state prosecutors to misstate to the jury what's required for recklessness under the law, the conscious disregard of a risk. The state was allowed to misrepresent that legal doctrine of recklessness to the jury. So if the jury found guilt on that misstatement of the law, that's an injustice, and the trial judge should have fixed that error. The defense asked them to. They said, Your Honor, that's a misstatement of the law, and the Judge Chu just didn't want to correct it. But that wasn't an error in self-defense per se. We had the Ahmaud Arbery trial with the McMichaels and Roddy Bryan, and there the judge refused to clarify what is meant by the 150-year-old Georgia citizens arrest law that was in play, that really was decisive in that case. It was ambiguous, and when the law is ambiguous, one, the judge is supposed to decide. He's not simply supposed to give the jury ambiguous law and let the jury decide what it means. And second of all, if it's ambiguous, the judge is supposed to interpret the law in favor of the defense. After all, the legislature had the opportunity to make the statute non-ambiguous when they wrote it. So if they didn't do that, the defendant shouldn't pay the price for the state's failure, the legislature's failure to write an unambiguous law. So it's that kind of thing. It wasn't too much self-defense defects per se, but they were legal defects that were sufficient to overwhelm a claim of self-defense. Here on, let me check the super chats. Super chats. Let's see. Contrarian 420. There has to be a beneficial first of all, thank you for your super chat contribution. There has to be a beneficial psychological effect on the jury for the state when they see the judge being annoyed by the defense. Yeah, I mean, frankly, this judge isn't really expressing annoyance. I mean, I don't think so. He's having to correct defense counsel quite a lot. But this is not, imagine if Judge Borkowski from the Edgecombe trial were presiding over this court. I mean, he'd probably be yelling at defense counsel, and then you would know that the judge was being annoyed. Here, I don't see it that much, but to the extent the jury may perceive annoyance on the part of the judge, yeah, of course, it has an impact. It shouldn't be a decisive impact, but it's hard to believe it wouldn't play any role. Kiernoff, thank you for your super chat contribution. He asks, do you still have hardcover signed books for sale? So we have our soft cover Law Self-Defense book, which we give away for free, folks. You can get it at lawselfdefense.com/free book. We do ask you to cover the shipping and handling. We have to pay for shipping and handling, so we're asking you to cover that. But we'll eat the price of the book. You can get this at lawselfdefense.com/free book. We also have a hardcover version, very nice hardcovers. You can get those at lawselfdefense.com/gethard. For many years, I autographed every one of these books personally. So whenever you ordered a hardcover, you knew you were getting an autographed version. It got to be too much, folks. So I'm not automatically autographing hardcovers anymore. We do have several hundred autographed copies still in the warehouse. When they're gone, they're gone. I don't know how many are there, folks. I'm not personally tracking how many autographed hardcovers are still left. If it's that important to you to get an autographed copy, you might contact support at lawselfdefense.com and ask them if they're still shipping autographed books. Otherwise, it's a crapshoot. But in any case, you get the hardcover of the book at lawselfdefense.com/gethard. And that is it. Let's see. Someone comments here. Barissone's attorney, Edward Blinkus, I believe that's correct, practicing 41 years, selected to super lawyers. 2006, 2010, 2018, 2020, 2022. I have to concede I've never been selected to super lawyers. I don't really know what's involved in that process. I will tell you that I regularly get solicitations telling me that if I'm willing to send somebody a bunch of money, they'll put my name in a fancy book of lawyers. I'm not sure how super lawyers works. But if this is what a super lawyer looks like, there's something wrong with that status, because this is not a super lawyer in this trial. Am I going to talk about Chad being found no bill by a grand jury? So this is a reference to the Texas porch shooting. The grand jury apparently returned a no true bill. Yeah, I guess I'll talk about it, but not in this show. I'll do it in a follow-up show. I'll only say that, a grand jury can return an indictment or not indictment for reasons entirely of their own, having nothing to do with the law. The grand jury can just simply decide, like a trial jury could, that, yeah, maybe technically that shooting was illegal, but too bad, he asked for it. And we're not going to subject this guy to a criminal prosecution under the totality of these circumstances. Could he be prosecuted? Sure. Successfully? Sure. But we're not going to do that to this guy under these circumstances. Doesn't mean the shooting was lawful on the legal merits. It just means the grand jury didn't want to go that way. So that happens all the time as well. All right, folks. Let me go ahead then and start this here. Those were all the questions to date.
The members of the jury, please, if you hear anything, just bring it to my staff's attention or raise your hand and I'll deal with it immediately. All right? Thank you.
I will mention that, unfortunately, one of the reasons we're doing these myth-busting webinars, in fact, while I'm talking about this, I'll pull up the little note for the myth-busting webinars again while I address this. One of the reasons we feel compelled to do these myth-busting, hard-to-convict webinars this month, 100% free, get your seat at lawselfdefense.com/hard-to-convict, is that many people learn their self-defense law from the media or from anecdotes like this front porch shooting in Texas and conclude from that outcome that must be what the law requires. For example, they might conclude that the grand jury returned a no true bill. That means this shooting was lawful. It doesn't mean anything of the sort. It means the grand jury chose to use their discretion not to return a true bill, not to indict this shooter. A different grand jury, different prosecutor, different presentation of the facts could very easily and legitimately come to a completely opposite decision and choose to indict. So when you're doing a legal analysis of these cases, you have to look at not what might have happened in some anecdotal case where people's personal judgment was applied, because other people will apply different personal judgment. You have to look at what's possible, what's permissible under the black letter of the law. That's the outcome you could face. It may well be that Carruth got a break here, a lucky break, and maybe he deserved it. I don't know. That's not for me to decide. But if a person is not charged or not prosecuted or not convicted because they got a lucky break, that doesn't mean the next person with essentially the same facts is going to get that same break. We can't conduct ourselves. We can't rely on what the system might do to us if it's feeling favorably disposed. If that happens, great. It's a bonus. I mean, grab it with both hands, of course. But we can't rely on that. We have to prepare ourselves for what the system can do to us if it's not feeling favorably disposed, if it's feeling malice towards our criminal defense, because then you're taking the whole ride. And you better have facts that are more robust than what's required for a mere lucky break. You need facts that are robust enough for a real fight. So those webinars, law of self-defense, hard to convict webinars, 100% free, but limited seats. We have 5 of these. They're all the same, so don't pick more than one, please. 5 of these, 100% free, but only 100 seats each. And of the 5, before I started the show, we had 233 people registered. So half those 500 seats are gone already. So if you're interested, you should sign up sooner rather than later at lawofselfdefense.com/hard to convict. And really, folks, the numbers are worse than that, because I think our system only allows us to put up the next 3 dates at a time. So we don't actually have 5 dates listed at any one time. We only have 3. So 3 webinars, 300 seats, 233 of those 300 seats are gone. I've been talking about this for 2 days and saying from the start, these things will sell out fast, folks. They always do. So don't wait too late. If you'd like a seat, you need to do it sooner rather than later at lawofselfdefense.com/hard to convict. All right. So back to our video here. Is that the right image? It is. Man, I'm getting good at this. I'll have to let Nick know. All right, here we go.
Goodwin,
Hold on, before we proceed, I'm sorry, can I see counsel at sidebar for one moment, please? The continued cross-examination of Mr. Goodwin.
Yeah, that was
Go
an
ahead,
edit by
counsel.
Law and Crime. They cut out that sidebar, dead space. Interesting. This may be a Nick Rekieta move, an anti-Nick Rekieta move, to say they're adding some value to the stream as opposed to, just dead airing it. And to the extent they're adding value to the stream, like if they were adding commentary, if Nick was reusing their commentary, that could be a problem from copyright purposes.
you saw the actual shooting of Lauren Kanarek, correct?
Yes.
Did you previously tell Corporal Thomas Fellini that after you talked to Michael Barisone, you turned to walk back into the residence? Then Lauren Kanarek walked over to speak to Michael Barisone.
Okay, so what they're talking about now is the actual culminating fight, conflict, where the shooting occurred. So my understanding of the evidence so far on this is that Michael Barisone had approached them, at least approached the boyfriend, although Lauren Kanarek was also present, approached the boyfriend, basically said, hey, can't we settle this? We shouldn't want a war, or I don't want a war, or words to that effect. And Robert Goodwin had said to him in response, listen, there's already lawyers involved. Let's let the lawyers deal with it. And then the boyfriend, this guy, this witness, turned and walked away from Michael Barisone towards the house in which Robert Goodwin and Lauren Kanarek were living. And Lauren Kanarek pushed past the boyfriend, walking towards Michael Barisone. And it's around this time that she was shot twice in the chest by Michael Barisone. So those are the events we're talking about here. So if the defense is going to make a case that there was an attack on Michael Barisone against which he was defending himself with that gun, now is when he needs to make that case. All right. Now, of course, if you ask the question of this witness has a motive to lie about that. But if you don't even ask the questions, you know there's nothing there.
Judge, can we come to sidebar?
Right. So
we
the state is concerned that in pursuing this line of questioning with the witness, the defense counsel is going to step outside the legal boundaries again. So the state's asking for a sidebar, saying, Your Honor, we just want to make sure that this is done in an appropriate way within the appropriate legal limits, and that this defense counsel is not going to go off the rails. And hopefully the judge, by now having this much exposure to defense counsel, will say, hey, counselor, just make sure you're not soliciting hearsay, you're not reading testimony into the record yourself, you're not misstating transcripts, that you're coloring inside the lines in my courtroom. That's not only the judge's privilege, it's his job. It's his duty to do that, given the performance so far of this defense counsel in this trial.
Word and clarify your questioning of the witness, please.
Mr. Goodwin, after the shooting, did you talk to the Washington Township Police Department?
I did.
Did you give them a statement right after the incident as to what actually happened?
I did give a statement.
Did you tell the Washington Township Police Department that after you spoke to Michael Barisone, you turned your back and walked into the house?
To walk back into the house. This is the problem, Mr. Blinkus.
See, again, this attorney, this defense counsel, is misrepresenting the actual evidence. He's trying to suggest the boyfriend was in the house and therefore perhaps not in a position to observe what's going on. Or maybe going into the house to retrieve a weapon, or who knows. But that's not the actual evidence. That's not this guy's testimony or statement to the police. His statement to the police was, I turned around to walk back to the house, not I turned around and walked into the house. And that small change, it means everything. And by the way, to the extent this defense counsel keeps getting called out for misrepresenting the evidence, the jury's not going to look on that kindly. They're going to conclude they're being lied to by defense counsel, deceived. In a self-defense case, assuming they're really trying to argue self-defense, which you hardly see at all, but everything relies on your credibility, the defense's credibility. That's everything at the end of the day. If they think you're lying, you're done. Why would they believe you?
Why don't you show it to him and ask the witness if that's what he said to the police?
It says walk into the residence.
To walk into.
That's why I said that.
All right, please proceed.
It's a good one. I'm going to show you defense exhibit.
And in any case, it hardly matters unless there's how does it contribute to a narrative of defense? Did he come back with a weapon? Did this defendant have reason to believe he was going to get a weapon? Because unless you can tie that together, it doesn't have any relevance. It's okay for someone to walk into their own home.
100C 14.6, which is an affidavit. I'm going to refer you to page 4 and point out a portion.
It's big enough. Thank you. Right.
And ask you to read that to see if it refreshes your recollection as to what you specifically told the police immediately after the incident.
This is a transcript of the recorded.
It's an affidavit. from the
I'm not
police?
familiar with
Okay,
what that means.
it's a sworn statement submitted by the police.
Responding to Claude in the comments, yeah, of course the jury doesn't have the same level of expertise as I do. They don't have the same level of expertise
not
as the
accurate.
prosecutor. Hopefully not as much as the defense attorney, although I have my doubts,
So is
nor
it
as much
your
as the judge. Of course, the
testimony
legal
that
professionals
you
have
never
more
told
expertise in the law.
the police
The jury's job is not the
immediately
law.
after the incident
The jury's job is
that
to
after
determine
you talked to
facts.
Michael
They're hearing the
Barisone,
facts.
You walked into the residence and heard gunshots?
That doesn't say I walked into the residence. It says, what's important in that thing is that it says that I did.
That the witness not comment on what's
Wow.
contained in the police document. This isn't what we talked about.
The judge is asking for another sidebar because, again, at best, defense counsel is being ambiguous in his questions. So, for example, say the police statement, and I don't know what it says. I haven't seen it, but imagine it says, I turned around to walk into the home. And the defense counsel reads it as into the home to suggest that he was in the home, that he had walked into the home. Those are two different things. But because he's asking the question at best ambiguously and at worst deceptively, it creates this problem, this confusion that the state has to call out and the judge can't permit.
Now, you observed Lauren Kanarek walking to Michael Barisone. Is that your testimony?
Correct.
And did you hear what Lauren Kanarek said to Michael Barisone?
So no matter what she said, if she said, I'm going to kill you right now, no matter what she said, if there was not also some overt physical act from which a reasonable person could infer an intent to carry out that threat imminently, to put it into execution, the threat is meaningless in terms of Barissone being justified in shooting her twice in the chest. You can't shoot someone over words alone. So even if it's true that she made some threat of imminent harm, there needs to be evidence of some overt physical act to put that threat into effect in order for that to be the basis for any kind of justification. Now, we still have other questions of, proportionality, of avoidance. In other words, did Barissone use too much force? Then you lose proportionality, the element of proportionality, and you lose self-defense. New Jersey is a duty to retreat state. Could Barissone have safely retreated, withdrawn from this 105-pound woman armed with a cell phone instead of shooting her in the chest? In New Jersey, that would be required if he had a safe avenue of retreat. He would lose the element of avoidance and lose self-defense. So even if she made a verbal threat, absent an overt act, it's not sufficient to justify defensive force. And even with an overt act, unless it was an imminent threat of death or serious bodily injury, to which is required for deadly defensive force to be required, and it could not be safely avoided by simply walking away from this slight woman, he still doesn't have a self-defense justification. Did she pull out a gun and point it at him? That's the kind of thing we would need to see.
She said she would talk to him, and as she was walking,
I'm asking what she said to him, not you.
I think she started to say something, and then Michael pulled the gun out and shot her.
When you say he reached, weren't you
picked
still
up-
Let him answer.
blocked by that huge bush and could only see from his chest up, as you've testified to?
So the other day, he stepped forward and reached out his arms before he shot Lauren. So, no.
Did you see him on the telephone?
Excuse me?
Did you see him on the telephone at any point?
No.
Did you see Michael Barissone's phone on a table in that general area at any point?
I saw a gun in Michael's hands, no phone,
And when did you see this gun?
when he pulled it up and shot Lauren.
Now, you said Michael Barissone's about 6'3", 6'4"?
Correct.
And you were standing on the label. How far up on his body could you see him from that location?
I think chest up.
Well, he could see the gun in his
Maybe a
hand,
little higher,
he claims.
Okay, so about from here to me?
somewhere about there, yeah.
And it's your testimony that he picked the weapon up high enough for you to see it over that bush and fire 2 shots
Yeah.
into Lauren Kanarek?
As Lauren was approaching Michael to have this conversation that Michael said he wanted to have with us, he took a step forward towards Lauren, raised up his hands and shot. So his arms were you understand what I'm saying? He stepped out from behind the bush at that point. He took one step from behind the bush when he shot. He was not aggressively, sorry. Took a step towards Lauren when he took the shot, when he raised up the gun.
All right, so let me see if I understand.
Sounds pretty aggressive, but
If you're on the porch, the bush is approximately what, 8 feet away from where you're standing?
Well, yeah,
And it's as high as Michael Barissone's chest, correct?
Correct.
Okay, and even though you're elevated, you only see from here up, correct?
Correct.
Now, it's your testimony from that position that Michael Barissone takes the step, what, to my right?
towards the gravel driveway,
Okay,
towards Lauren where she was standing.
and raises his hand and shoots her.
Correct.
Now, how tall is Lauren Kanarek?
what color are her eyes? You
5'5",
won't know the answer.
5'6".
When's her
Can I assume
birthday?
he
Just
raised the
embarrass
gun
him
up
with
this high
relationship
to shoot at
questions.
Lauren Kanarek over 5'5"?
I think that would be pretty accurate, yeah.
Okay, and and this is based on what you're testifying you saw, the gun was about where when he fired the shots that like, straight out from his arm as I'm holding it? Approximately 4 feet, correct? Approximately.
I'm sorry,
What are you asking me?
What
How
are you saying?
high was his arm raised?
He just
raised his
showed
hand.
you.
He extended his arm.
And you could see that over the bush.
Asked and answered.
Do we
It's
have a
up to the
picture?
jury
I'll-
to
I'll-
decide whether or not they
he
believe this
stepped
guy.
One step forward out
One step forward out.
to the driveway, which was enough to be unconcealed by the bush 100%. And I don't know if that bush was there, if it would block his arms. Because like I said, I definitely could see his shoulders. I saw his arms come up when he talked to me, when he came up to talk to me. So if he held his gun up, I think it'd be pretty reasonable to say that I saw it still. If he stood in the exact same position he tried to lure us out of the house from.
He tried to lure us out of the house.
When you say lure
Well, maybe he did.
us out of the house, you and both Lauren came out on your free will, correct?
I think he tried to pull us to his area. I came out to the porch. I did not want to conversate with him.
Why are you
I told
letting
him the
this witness
attorneys
do
will
this?
handle it. I believe his intention was to pull us out of the house.
Why are you letting this witness provide this narrative testimony in front of the jury? You can ask the judge to constrain the witness to answer the actual question and no more than that. You can interrupt the witness and stop them if they go into a narrative.
I asked you, when you first observed Michael Barisone, if you would describe him as sorrowful. And you didn't even seem like you understood what I was asking. Is that a fair statement?
Yes, I did not recall it. I don't know. And also you were very vague about, was he sorrowful within the 2 years that I've ever met him? I had no contact.
No, I'm talking about
That doesn't
I didn't know.
surprise me.
moments before the shooting. I'm talking about the day of the incident. Did you tell the police in your official version he looked really sorrowful?
Really? That's going to be that's the key issue here, whether or not he looked really sorrowful.
Page 4, bottom of the first paragraph.
Where's it at?
Page 4, bottom of the first paragraph. You need my glasses? Or?
No, I can see this. Bottom of the first paragraph.
Bah, 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 bah. Yeah, so I mentioned this maybe yesterday. I forget now. Jury nullification. So jury nullification is
Did
both
you describe
not a thing and
your
is a thing.
observations
So it's not a
of
legal
Michael
doctrine.
Barisone
It's not something.
immediately
There's no
before the
jury
shooting
instruction for
as
jury nullification.
sorrowful?
It's not
It says
supposed to
here I
happen.
did,
The jury is supposed to apply the
I
instructions
recall that.
and the law
I don't
as the
recall
judge
saying this,
tells
no.
them to do, whether they like the law or not, whether they think the law should be different or not, and the judge will tell them all that. You have to apply my instructions, whether you like the law or not, whether you think it should be different or not.
Okay. And at that point,
And they're all told this when they're first seated as jurors, and
is it
again
fair to say
before
that
they
you
go into
had no
deliberations.
love lost for
So
Michael
the judge is telling them,
Barisone,
you can't
and
just
you weren't
nullify a
saying
law you
anything
don't like. That's
trying
not up to you.
protect
That's not
him?
permissible. And the lawyers are not allowed to argue
I
that.
think this is
to a
consistent
jury.
with what I'm saying is
That said,
sincere,
and if jurors were
sorrowful,
making
he
those
tried to
arguments to
draw
each other in
us out of the
deliberations, it
house
would be misconduct.
to him so he could shoot us.
So it's not a legal thing. Jury nullification is not a legal thing. On the
Did
other
you
hand,
say
it's
I
a
could
practical
only see
reality.
from the
If a
chest
juror
and
in their
above
own
when you
head,
said something
without telling
like,
anybody,
"He looked
simply
really
decides they don't like this law,
sorrowful,
they
you
will
know."
not convict this defendant of this criminal charge,
What did
they can
you
just vote
say?
not guilty.
You
They don't have to
believe
explain that to
me?
anybody. Nobody would know it was jury nullification.
He looked sincere in saying, how do we work this out? I personally did not care because
But my specific question is, did you use the term sorrowful?
it says right here, I said sorrowful. I agree.
So will you agree with me that calm and sorrowful is a huge difference between angry?
I never said he was angry.
And would you agree with me that based on your entire observations, the entire incident, he never appeared angry, correct? Correct?
We just went over this, yes.
Did he appear? He didn't appear angry until he shot my girlfriend twice in the chest. Yeah, I mean, it's quite possible that both Lauren Kanarek and this boyfriend, Robert Goodwin or Goodman,
Just
are
testified
completely
on-
lying sacks of garbage,
To my last question. that
very
you observed
malicious,
Michael
bullying,
Barisone
destructive
shoot
people.
Lauren Kanarek from
That's
the
still not
landing on
justification
top of the
to
stairs, correct?
shoot them.
Correct. I was on the landing.
Today,
Did you tell the
every
police
state
in your
requires
official
a unanimous jury
That
to
before the
convict
shooting,
or
you
acquit.
came down the stairs.
There were two states. I think one was
Downstairs
Oregon,
from-
and the other was
Before the
Louisiana,
shooting.
where they
Yes,
used to
I was
allow for,
upstairs on the third floor
instead of
apartment.
unanimous
I came down
verdicts,
some
super
stairs.
majority verdicts. So 10 out of 12 or 5 out of 6 would be enough. But neither of those states allows that anymore.
Can you look at page 3?
Yeah, and maybe these witnesses are well prepped. I get that sense too. They would have been well prepped by the state, or perhaps by Lauren Kanarek's father is a lawyer. So it certainly seems to me like they otherwise don't appear bright enough to do this stuff on their own initiative. Make these very carefully crafted remarks.
At that point.
So I expect they
Is
were
that
prepped,
your
but there's nothing
sworn
wrong with prepping a
testimony?
witness. That's permitted. You can't tell a witness to lie, but you can prep them. You could say, emphasize this, don't emphasize that, use this word, don't use that word, without lying, and that's all fine.
I believe that's in reference to me coming down the stairs from the apartment.
Well, when you said Lauren walked down the stairs, where was she walking down the stairs in that specific sentence? Where was Lauren when you were walking down the stairs? Was she outside at that point?
She was behind me,
Well,
and then she
you
walked
agree
down
with
the
me
stairs.
that you told the police she walked down the stairs to talk to Barissone, and then 2 shots were fired. Isn't it a fact? You were inside when the shots were fired.
Yes, if one juror is sympathetic to this defendant, they can vote not guilty just because of that, and nobody would know.
Now,
And you'd get a hung jury and a
quickly
mistrial,
were these
and then
shots
the
fired
defendant would be
in
subject to a retrial with a different jury.
Very
Probably
quickly,
the same judge, though.
stopwatch. Boom, boom.
okay, and then
Apologies.
how quickly after that was the shot you claimed was fired at you?
Took 2-3 more steps, turned to me and fired at me. So a couple of seconds,
Okay, so
some sort of a pause in between the two shots fired at Lauren. Little hesitation, maybe a pause, whatever you want to call it. Aimed at me and fired at me.
okay, boom, boom.
Yeah, I would suggest it's
Boom.
professional
Boom, boom.
incompetence for a lawyer
Boom.
not to prep their witnesses. I mean,
Now-
unless they just don't have time. I mean, a lot of public defenders, there's no
Were those
time.
shots
They're hopping
loud?
from one file to the next file, doing
Not
multiple
overly, no.
things a
I don't
day.
think so.
they don't have the luxury
I mean, they
maybe
were loud,
of
yes,
prepping
but-
witnesses in depth.
9mm.
But if you have the time, the
Yeah,
opportunity,
That'll be a
I
reference.
I think it's
right?
professional misconduct not to
You're
prep your
familiar
clients.
with 9mm. Was it a loud boom?
Yeah, I have the
Was-
again. If you
was
came in
as
late,
loud
I
as,
do. I found the old drunk
Lawrence gun.
lady committing a simple battery upon me in a saloon in Durango,
Did you
Colorado,
tell the
just
police that
just under a year
after-
ago, last May. And I'll share that video with all of you who hang in there to the end
You
of this
fired at Lauren.
debacle of a cross-examination.
That you ran in the house. Did you tell the police that immediately after the incident?
Sorry, can you rephrase it? Or can you say it again?
Sure. Did you tell the police that after
It looks like we have about another half hour of this, folks.
Lauren was shot, I kind of ran in the house?
Make that
Did you say that?
yeah,
I
35
dove
minutes.
into in through the door as Michael raised the gun up at me.
Did you say I ran in the house again, a second time in your official statement?
I dove into the house. I remember seeing the tempered glass windows shattering around the floor as I was laying on the floor. So if I did it, maybe it was a misspeak. I'm sure throughout here we'll find more. Do I have a
Now-
minute to read this?
Most of the time, when people are complaining about a judge in the way that I guess the law and crime crowd is complaining about this judge, it's because they've already picked a side and they only want the judge to do things that are favorable to their side. And anything the judge does that's anti their side must mean he's a bad judge acting out of malice for some reason. Plus, they
Isn't it a
have
fact
they
that
have no
after she got
um,
shot,
informed
she ran
context
away?
in which to understand what
And you
judges
have
are actually
no
supposed to be
idea
doing
where she
in
went.
their courtroom. There's nothing wrong with this
I
judge,
did lose contact.
At
so
least
I dove into the
as
house
we've
of
seen
where
in,
she
in this
went.
cross of Lauren Kanarek and this
Did she run around the house?
her boyfriend Robert Goodwin.
Based on your observation.
Obviously, I don't know everything about this judge or everything he's done.
She ran
Not even
away
everything
when
he's done in this
Michael-
trial,
after
but what I've
Michael
seen
shot
in
at
this
her,
cross examination,
She
he's been
turned
fine.
around, ran away. Pretty shortly after, he raised the gun. at
Shorter
me, and I
answer:
dove
people are
into the
complaining
house,
about
so
this
I did
judge
not
because they're ignorant. That's why.
see if Lauren ran around the house.
Did you ever tell anyone that Lauren disappeared and you think she ran around the house?
I don't know what Lauren did after I dove in the house.
Well, you weren't in the house for any length of time, correct?
I dove on the floor and I got up and I charged out. At the time, Michael was charging in.
Okay. And was Lauren there in the immediate area at that point?
Lauren was there because on the conflict on the porch, when Michael brought the gun up and I had him in a chokehold, she grabbed his gun hand and tried to pull it down. I
Okay, so,
assume
go ahead.
I assumed he was going to try to shoot at me over his head, over his shoulder.
So one of the theories has been that if this was self-defense, because Michael Barisone was beat up and he had bite marks from the couple's dog. So if that beating and biting occurred prior to the shots being fired, then perhaps the shots were being fired in defense against that beating and biting. But all the evidence we're hearing, and we're hearing nothing contrary to this, is that the physical grappling between Barissone and the couple and the dog biting occurred after the shooting, which would simply be them defending themselves against getting shot again, and the dog defending their owners.
But Lauren jumped on his arm and held his gun hand.
Now, did you ever tell the police that Lauren Kanarek was up on the stairs grabbing at Michael Barissone's arm with a weapon in your official statement?
I would imagine I did say that.
Can you look at page 3, same paragraph I'm talking about, and see whether or not it refreshes your recollection as to whether you ever mentioned that Lauren Kanarek and you were on the stairs trying to get a gun away from Michael Barisone.
These long, you can't allow this as defense counsel. These long pauses, it just, so I would normally say it diffuses all the energy out of cross, but there is no energy in the cross to begin with. So I guess in that sense, it's harmless. Again, just bad form. Yeah, I mean, is he trying to poke enough holes in their two stories? I don't see the big gaping holes. These are little detail things that witnesses normally, it's very common for witnesses to their testimony to not be 100% consistent with each other. If it was 100% consistent, you'd figure it was rigged. Of course, people don't even remember. If you take a deposition and 2 years later you ask the same person the same questions, you get slightly different answers. That's just the way the human brain works. And certainly statements from two different witnesses experiencing two different perspectives and experiences and events, it's going to be slightly different. There's no contradiction on anything that's pivotable, See, folks, you follow law self-defense, you get free new words. There's nothing that's in contradiction between the testimony of Lauren Kanarek and her boyfriend that's relevant to any pivotal issue in the case.
Not in that paragraph, it does not say that.
When you say a paragraph, that's the paragraph when you talk about the actual shooting, correct?
The paragraph I just read.
And nowhere in there did you mention that Lauren Kanarek was on the steps struggling with you and
She
Michael.
wasn't on the steps.
Where
Said
was
she
she?
reached up while me and Mike were on the steps. She was on the side of the railing. She reached up, tried to grab Michael's arm.
with her feet on the ground?
I mean, it almost
She was
feels
on the
like
steps.
the
She was
real
behind
defense
Michael.
lawyer for this case
She was-
was like
The
It was
question
me,
is,
kidnapped
Michael,
by
Lauren.
space
I
aliens,
saw
so they
Lauren go
grabbed
up
his
and grab
twin
hand.
brother,
I don't know.
who's never been a lawyer, to step in and play the role of lawyer.
She was on the steps, correct?
I'm not entirely sure that's accurate.
All right, I'll ask it again. Where exactly was Lauren Kanarek where you say she reached up and tried to grab Michael Barisone?
She was on would be Michael's front side. On the other
So
end of
today,
the-
folks, I'll
Michael.
probably end up having put 7
All I
hours
saw were
into
her
this
hands
dopey trial.
They were
And that's
wrapped around
just
his
looking
arm
at the
as he was
cross-examination
trying
of Lauren
to pull it
Kanarek
up.
and her
She was trying
boyfriend.
to
Not
pull his
even
arms down.
following everything.
Again, I don't want to belabor this point anymore, but you don't know whether she's on the steps or she's on the ground.
I was concentrating on the gun that was coming up to my head.
Okay, and when you're talking about this.
Yeah, she was
specific
shot
incident,
twice, but it's
Michael
possible to be shot in
Barisone
parts of the body where it's
his
not
back is
debilitating.
to you, correct?
Obviously, it wasn't for her. She says she was losing a lot of blood, but she wasn't losing too much blood, or she wouldn't have been here to testify.
And had you struck him in the head at this point?
Question, yes.
And did you knock him out?
Yeah, honestly, FN lawyer's right. I mean, I would expect a reasonably competent paralegal of any experience to be doing better
When the gun,
at this cross than this criminal defense
according to
attorney.
you, is in Michael Barisone's hand, both you and Lauren are struggling with him to try to get the gun, correct?
No, I was struggling to stop him from murdering us.
Okay, well, you saw the slide back and immediately recognized that the gun was empty before you leaped out and struck him according to your testimony, correct?
That is what I said.
So there was no danger in any other bullets being fired.
Unless he had
based on
another
your
mag.
observations of
The guy
Michael
just shot the
Barisone.
woman twice in the chest and shot at this
I
dude,
don't know if
shattering
I
a
was able to
window.
process.
You don't have to leave the
I don't
gun
know
in
if I
his
was able
hand
to
just because
process
it's slide locked.
What was going on? I was very unfamiliar with the gun. I did not know the full extent of processing it. I mean, I watched Lauren get shot, and yet I didn't realize she was shot until I saw the holes coming out of the back of her shirt. So it was a very stressful, fast time.
We'll get to that point in a second, but let's talk about something else first.
So there were exit wounds here. Exit wounds would be more consistent with ball ammo than with hollow point ammo that would expand and has a greater likelihood of staying inside
You
the
say
body it struck.
you physically see, not here, but physically see Michael Barisone shoot Lauren Kanarek, correct?
Or, as Insanity Pepper notes here, the slide might not have really been locked back. It
With
could have been
that
a double feed or some other
You
malfunction
didn't
where
even
the
realize
slide's in a
that
rearward
she was
position, but a
shot.
tap rack bang gets it
Is
right
that
back
your
in play.
testimony? Even though you claim to have seen a gun, heard the gun fire twice, you did not realize until after you started beating Michael Barisone that he was shot, she was shot. Is that your testimony?
She did not, let me rephrase it this way. She did not fall on the ground after being shot. There is a possibility that maybe she was missed. We get those possibilities out of the way when I'm looking at holes coming through the back of her shirt. That is when I realized she was shot by Michael.
Now,
Yeah, these questions are just so
You'll
loose
agree
and
with me
ambiguous and
when
open. They really should be tighter. And he should not only be asking
believe
tighter
that
questions,
Michael
he should be
Barisone
constraining this witness to
and-
tighter answers.
cracked him in the face. That was the first punch that you landed.
Correct.
Now, didn't Michael Barisone have his back to you at that point?
No, he was charging into the house and I was leaping out of the house.
When did he turn his back on you?
Well, after I punched him, he looked dazed for a little bit and then out of nowhere just turned and went to go run off. I don't know if he was where he was running to. I don't know what he was doing. I don't know what he was thinking.
Yeah, most lawyers, folks, are
He
not
turned
trial
around.
lawyers. Trial lawyer, you
I
can
don't
think
know
of it
if
as
he
a
was retreating or
specialization
what, but he turned around
all by
and gave me
itself.
back.
Most lawyers never go to trial.
Where exactly on Michael Barisone?
Certainly not an adversarial trial. They may go to trial to file papers or motions or that kind of stuff, but that's different than the actual
When he
adversarial
turned his
setting.
back and attempted to get away, is that when you leaped on his back and started to choke him?
I'm sorry. I just said I don't know what he was doing, so I'm not saying that he attempted to get away.
Okay.
He could have been going to finish killing Lauren. There's nothing that states he was trying to get away. He was a man with a gun on our property trying to kill us. I subdued him.
Okay, so
Well, that was helpful. Thank you, defense counselor. that was all helpful for your client.
he tries to
He turned
walk
around.
away from you, correct?
He turned around.
Turned around. And at that point, you jump on his back and you start choking him.
At that point, I threw a chokehold right on his neck.
And is he still on the stairs at this point?
We're either on the patio. I think we're right on the top, not the patio, sorry, the porch, the little porch. We're on top of the porch at that point. Maybe one step down. I don't know. We're on the porch.
You're saying you don't know whether or not you were one
So-
step down?
You're on the landing
Jeepers.
or the first step going down. Okay, that's what your testimony is?
Pretty close to it, yeah.
So is it safe to assume that when you struck him in the forehead, he was on the landing?
That is correct.
Did he attempt to turn and walk away while he was still on the landing?
Hey, if anybody wants to sign me up as a super lawyer, go right ahead.
Okay.
That would make for a
And
funny show.
started to walk down and only
Super
got to
lawyer.
the first step, correct? According to what you just said.
I feel like we're having a.
I'm waiting for a press release to come out from the super lawyer organization.
You indicated he's on the landing.
We are refunding this guy's check
You hit him.
and
in
we
the
want our
forehead.
certificate back.
He turns around, he's still on the landing, and he's either on the landing or he's taking his first step down. and you
Does it come
jump
with
on
a
him
cape?
And start choking.
Does your super lawyer
Correct.
certificate come with a
As soon
cape?
as he turned around, I was on his neck.
Okay.
As soon as he turned around, you got to remember this is a fight for my life, Lauren's life.
Right.
So
Okay.
as soon as he turned around, I tried to subdue him.
Okay. And where was Lauren at this
Comes with
point
special
when he's
pajamas.
At the top of the stairs, trying to grab at the gun.
Oh man, this witness is looking so tired, and that's what
Time
the
I see
jury's
Lauren
feeling
is when the
too,
gun
folks.
comes up, Lauren jumps on his arm to protect me. At that point, we don't know the gun is jammed or anything of the fact. And like I said, even seeing it, I did not recognize, it did not process in my head that that gun was no longer a weapon because the slide was locked back.
Didn't you tell the police that the reason why you decided to charge at Michael Barisone is because you saw that the slide was back and realized that the weapon had no bullets in it?
Please show me where I was set anywhere.
Oh my God. He better be able to back this up. I mean, he will look like a complete fool if he attributed in an adversarial way these words to this witness, and he cannot show in the record where those words are.
Now, when you were choking.
Oh, he
Michael
can't do it.
Barisone,
He can't do it.
pass
He's
out?
moving on.
He did.
And where's Lauren Kanarek at that point?
That's
Lauren
not me
Kanarek is on
coughing.
the side
That's
of
the judge.
stairs. All
At least he
grouped
ran
in
out of
one
paper.
section.
I haven't
We
heard
got
all the
pictures.
paper
It's easier
shuffling.
If I just show you, then I explain.
Now, at this point in time, were you down on the concrete patio?
I was on top of Michael and we were both on the patio.
Did you slam Michael Barisone's face into the concrete patio?
We passed out, we fell onto the patio, onto the concrete patio.
At any point in time in the struggle, did you punch him in the face?
When Michael was coming back to, he was trying to get back up. I did punch him
How many
and I did
times?
hold him down.
How many times did you punch Michael Barisone in the face?
1,000. What difference does it make? I mean, in this sequence of events, all this is happening after his girlfriend was shot twice in the chest and Michael Barisone had shot at him. After. And this guy's not on trial. This Robert Goodwin is not on trial. So what difference does it make how many times he punched Michael Barisone after Michael Barisone shot his girlfriend twice in the chest and shot at him? How is that relevant to the criminal charges against Michael Barisone?
Enough to get him to not get access to the gun anymore.
Do you have any idea how many punches that took?
I mean, this is a fight for my life, so was I concerned about how many times I was punching the man that is trying to get up? I was not, and no.
If I had to do it again today, I'd punch him 10 times as many times.
The matter is, he was trying to get back up.
And did you punch him on the side of the head, in both ears?
I punched the whole head, every part of the head.
I do not know.
Have you seen any pictures of
Did you call a
Michael
code red?
Barisone looked like after you got done punching him and hitting him?
I saw him on his first court hearing.
Now, at some point in time, did Lauren Kanarek start beating Michael on the side of the face with her telephone?
I just saw in the comments a plea of 10 years was offered and rejected.
Just about.
I think I read that elsewhere as well. So let's assume that's the
And
case.
It's your
I
testimony.
Man, that would have been a gift from
I
heaven
did.
For this defendant.
Want her
And I
to,
don't know if his
you know,
lawyers didn't work hard enough to convince him, because I would have been on my
Want
knees
her to
begging my
stay
client to
alive.
take that
This
offer on
is-
these facts. But ultimately, it's
You
the
know,
client's decision. He has
I
to
don't know.
agree to
My
take the plea.
focus was that
And no matter how much you
she
argue
just
with him, no
needed
matter
to
how much you tell him
press
it's in his best interest,
or hold the blood in.
the client has to agree, and he'll be asked
prefer
in
that
court
to
whether or not he
what you
concedes to
would be
guilt on
doing,
whatever the
you know.
compromise
Okay,
or
but
the plea
did she
conviction is, and
beat
all
Michael
that in open
Barisone
court under oath.
for approximately 7 minutes
So if the client doesn't agree, it doesn't happen.
No.
during this incident?
No.
How many times did you see Lauren Kanarek hit Michael Barisone with her telephone? in the
Again, this is
ear
all
and the
after he
cheek
shot
area?
them.
few times I've seen Lauren. She was also in the fight for her life. Okay. She hit him a few times, but at this point she was very, very close to passing out, and she couldn't even stand.
Imagine if these two people, if Lauren Kanarek and this boyfriend, Robert Goodwin, were the defendants in this case. They were being charged for their use of force upon Michael Barisone. They have an incredibly robust self-defense narrative here, right? He just shot them. Shot Lauren Kanarek twice in the chest and shot at the boyfriend. They have a self-defense narrative, but they're not on trial. They're not on trial. They're not being charged with anything. They don't have to justify their use of force as self-defense. It's not being contested as anything other than justified. So I have no idea what this lawyer is doing here except to present these really apparently despicable people as heroes, survivors in a fight to the death against a deadly force aggressor. Jeepers.
So I do not believe there was any sort of damage done from her hitting. She may think she did some damage. You may imply that she did some damage, but at this point, she was almost dying.
Okay, incapable of walking around at this point, correct?
At this point, she was on the ground, yes.
Incapable of walking up the stairs and getting an object from the landing, correct?
We're talking about after I subdued Michael. Yes, you're implying before.
No,
Before.
I'm not implying before. Listen to my question. Your testimony, and correct me if I'm wrong, is that immediately after the shooting, you strike Michael, he turns his back, you choke him, you fall to the patio area, and you start to subdue him, correct?
That is correct.
And Lauren Kanarek is there the whole time, on her knees, correct?
From when I had Michael on the ground and we all fell on the ground.
Right?
Yes,
down
she
from
is
the-
right there with us.
She's right there with you, and she starts hitting her with the phone. You saw that, correct?
I just said that.
Okay. Do you know how she got her phone to hit Michael Barisone, which wasn't available to her at that point?
Yeah, Mr. Belinkus, don't editorialize, please. Just ask the question. Do you know? Do you know?
I didn't.
Re-ask
I
the
didn't.
I know. Just re-ask the question and don't editorialize. Just ask a question,
Did you see
please.
Lauren Kanarek leave the area, walk up the stairs, grab her iPhone, come down, and then start beating Michael Barisone? She never left that area, correct?
At that point, like I stated, she was pretty much
Dying.
dying.
Okay. And can I assume that after that, you didn't see her go back up the stairs again and get a different phone and come down and call 911?
She had my phone from the minute I walked down the stairs from the apartment.
Correct.
Did I give it to her either?
Mr.
I'm not-
Belinkus, again,
Okay.
you know, we don't need your comments about the testimony. It's inappropriate.
Understood.
You don't say correct when a witness answers. Don't do it again, please.
She had your phone when she came to talk to Michael Barisone, correct?
Another annoying thing this defense counselor does is his repetitive, are you saying under oath? Is it your testimony under oath? Many judges will not allow that. The witnesses under oath, the jury saw them being put under oath. You're not going to be allowed to repeatedly imply without basis and evidence that the witness is lying by constantly asking them if they know they're under oath.
Definitely had my phone, yes.
And this whole shooting, the sequence of events would be heard by the lawyer who was on the call, correct?
I assume, yes.
And after you struck Michael and choked him She was down on her knees, close to dying the entire time, correct?
From that point on, yes, till the police showed up.
You never saw her, and correct me if I'm wrong, her going up the stairs once or twice to get something.
No,
She wasn't even capable of doing that based on your observations of her medical condition, correct? Correct?
yes.
Again, I don't know anything about this defense lawyer or his history. I'm only judging based on what I'm observing on his cross-examination of Lauren Kanarek and this guy, the boyfriend, Robert Goodwin. That's it. That's all. My 100% of my exposure to this lawyer is these two cross-examinations, and it sucks.
Now, did you see Lauren Kanarek running around in a circle at any point?
Like a chicken that had been shot twice in the chest.
Assume we're talking about the incident. I do not recall her running in a circle. I recall her running away from Michael. And when I say run away, I saw a few steps before Michael aimed a gun at me and I dove inside. So
At any point during this incident, did Michael Barisone say anything to you after your initial discussion with him?
no.
Well, I was choking the shit out of him, so. Oh my God. Step it up, counselor. Everybody wants to go home for the day.
Now, when you were subduing Michael Barisone, did you tell the
Why would you
police
say subduing? I mean, if you're going to try to characterize it as some kind of misconduct on this witness's fault, and if not, why are you bringing it up? Why not say attacking?
or words to that effect?
After I punched him or after he was choked out?
After he was choked out?
After you, I mean, no, he was choked out. And then when he was coming back to consciousness is when he was moving around and trying to get up.
I mean, you almost hope that Barissone's really is so insane that he can't recognize this debacle that is his defense counselor. So the boyfriend story and the girlfriend story don't have to match at every point. They only have to match on the relevant points, the pivotal points.
Anything further, Mr. Belinkus?
Yes, Judge, I'm just going over my notes.
Well, jeepers. The judge wants to go home too. He's like, I am done. I guess this is the morning. Maybe just needs a bathroom break. This is awful. Ah. Can the witness get in trouble for face palming and groaning on the witness stand? Well, except the judge feels the same way. I don't think I've ever seen a public defender do this poor job. And many public defenders, as I've said very often, many public defenders are world-class attorneys. Few criminal
Did you tell the police
defense attorneys get
immediately
the kind
after
of trial
this
time
incident
that public defenders get
you
as a matter of
thought
course.
Michael Barisone had psychological problems?
Objection.
That was your,
Hold on, there's an objection, Mr. Belinkus. Please,
Mr. Goodwin,
the objection sustained.
Mr. Goodwin,
Again, Law and Crime did a little cut there. Thank God we didn't have to sit through that sidebar. But Anytime you start to bring up psychiatric stuff, many states have pretty strict laws that any kind of mental health care stuff is privileged and not admissible in court, absence certain exceptions. But just treading into those waters is hazardous for an attorney in a criminal case.
At any time during this incident, did you observe anything that would indicate that Michael Barisone was having psychological problems?
Objection.
That objection was
Same
just
question,
sustained.
different
Right,
format.
it was dressed up, but focusing on it, the question
And
is not, we know you're not an expert. All right, so counsel's just asking what observations you made about.
I don't understand the people calling out this judge. I think he's being remarkably polite and professional under these circumstances, dealing with this defense lawyer.
I'm not really.
The judge
sure
just
I've
say he
answered the
dressed up
question.
the question. Jeepers.
All right, ask another question, Mr. Belinkus.
Well, he put some lipstick on that question, but you know, objection sustained. I mean, he's had 2 years to prepare for this trial, and he's doing. What is he doing? Folks, the criminal defense attorney should show up. Again, maybe not if it's a public defender, they're so overworked, but it's certainly a private criminal defense attorney. They should know every facet of this case inside and out. I don't know what all this note checking is. Judge, give him a poke.
Now, with regards to your observations of Michael before the shooting, you've already testified that he was calm and sorrowful.
We know he shot the woman twice in the chest. I mean, there's no evidence contrary to that. Was he calm and sorrowful when he shot her in the chest? When he shot at this guy?
As sincere when he said, "How could we end this?"
My first impression was, yes, it was a sincere gesture. I couldn't tell you if he was sincere or if he was just trying to lure us out of the house.
And he mentions the term war, correct?
He did.
And were you aware, and did you personally see Lauren Kanarek's
Well,
constant?
it's a compound question.
Okay. Did you,
I mean, it's just bad form.
Lauren Kanarek's use of the term going to war numerous times throughout the last 2 or 3
What's
weeks
numerous
leading up to
mean?
the incident?
I have no context to it, nor do I remember specifically anything you're talking about.
I thank all of you for sticking with this so long, except I know you're waiting for the video of the old drunk lady attacking me in a saloon in Durango,
Did your
Colorado.
dog
I will be
attack
sharing that as
Michael
soon as this debacle of a cross is over.
When we were on the concrete
I
patio.
really feel I owe it to
got
you now.
out because I didn't have time to close the door as I was trying to control the situation. So yes, at some point I noticed Rosie when me and Michael are tied up on the ground and I'm subduing him.
Did you see Rosie biting Michael Barisone?
I believe Rosie bit me as well.
Did you see Rosie bite Michael Barisone?
I did.
Yes or no?
Yes.
Did
Rosie.
you see Rosie bite Michael Barisone in his inner groin area next to his genitals?
He was face down, so I couldn't imagine how that would happen, but
Now,
Anybody seen a picture of the dog?
Did you break?
Wonder what kind of
Michael's
dog
arm?
Rosie is.
I did.
Is Rosie a pit bull with a
Did Michael
prison
pass
tattoo and a
out at
grill?
any point in time during this beating?
That would be funny.
So Michael.
Although I
In
guess if it
addition
was
to
a
what he
pit bull,
already
we wouldn't be
testified
having the
about?
trial.
When he put him in the chokehold, you meaning after that point
After
in
that.
time? So
Oh, after.
after the chokehold,
Yeah.
he's asking.
Again, these ambiguous I just don't. I don't get it.
Were you aware that?
Nobody knows what you're talking about. What you're asking about.
Had a gun at the facility?
No.
I mean, not that it matters really. If the dog was biking Barissone after he shot these people, the dog's just defending the owners.
No.
The dog's moment of fame captured on a 911 call.
The day before the shooting, when the townspeople were there.
We're
at
back to
some
the
point,
townspeople with the zoning
did you
violations.
take your finger and form it into a pistol, pretend like you pulled the trigger, and mouth the words to Michael Barisone?
I would choose
Yeah.
B. Ivory if there was a racial disparity for sure. I would choose B. Ivory. B. Ivory was not a very good lawyer, in my opinion, but he brought theater to the courtroom, and that could influence jurors. Absent a racial disparity, though, I'm not sure it would have the needed impact. Maybe theater still can have the needed impact. It would be better than this. I mean, this is suck without the theater. I'd rather have, if I have to have suck, please layer some theater on. And nice shoes. You talk about B. Ivory. Did B. Ivory have nice shoes? He had a nice suit. He cleaned up nice. Yeah, he certainly looked like a lawyer.
I'm going to show you a series of pictures. 800. Sit. 852 to 865.
And when I say my impression was that B. Ivory was not a particularly good lawyer, I don't mean that in a personal sense. I'm speaking from a technical perspective. I hope people understand that.
Just be careful when you view those, Mr. Shellhorn.
Judge, I think the witness has already said that he's seen no pictures of the defendant after this all happened, so I'm not sure what the relevance.
Let me see it.
Oh, right. And B. Ivory's shoes were squeaking or something, weren't they? Yeah, I remember that. How old was the lady that battered me in a Durango, Colorado saloon? You'll see her picture. It's actually I captured her on the video. I had forgotten that I had, but you'll see her. And I'll have to do a little bit of setup before I play the old lady attack on your favorite self-defense lawyer video, because I had misremembered a couple small details, but I'll set it up and then then you can all enjoy the video at my expense. No, I'm not pressing charges. I was glad she got kicked out, though. I wouldn't have wanted to
That
have
objection was
continued to have to
sustained.
deal
There's
with her.
something else, Mr. Blinkus, please.
Come on, Belinkus, just wrap it up. You're not getting anywhere here.
Mr. Goodwin, after the police arrived,
So how many times did he shoot your girlfriend?
you had an opportunity to see Michael Barisone. there, correct?
I don't know what capacity you're talking about. I did see him there after the incident, yes.
And would you agree with me that his face was filled with blood?
Filled with
Wasn't
blood.
Concerned with what Lauren was
I understand that.
doing.
He's got
With
2 minutes to
regards
go here,
your
folks.
Observations of Michael Barisone, would you agree that his arm looked deformed? Did you see that?
I don't know how he looked after. I did see him. I did not assess him, is I think what you're asking for, an assessment of what I thought of Michael after the incident.
Okay.
I assessed Lauren.
My last question.
God, thank God.
The week leading up to this incident, things were extremely toxic, correct?
They were tense.
Can you tell the ladies and gentlemen of the jury?
I don't believe for a second
Why?
this defense counselor has 3 decades of
August 3rd,
trial experience,
2019,
not as a defense
you
attorney.
were searching Mary Hassett,
Objection, Judge.
11-year-old
Objection,
daughter.
Judge. Objection.
Mr. Belinkus.
Again, terrible form. I mean, these lawyers know when there's an objection, you stop and you wait for the judge. You don't just keep talking through it. It's not your courtroom. It's the judge's courtroom. That's it. I hope.
You have anything else, Mr. Belinkus?
It's going to
No,
spend.
Judge.
How long's your redirect?
I think it will be before the lunch break, Judge.
All right.
All right, I'm not gonna cover the redirect, folks. That's it. We've had enough. Again, just like the so for all the people who told me at the end of yesterday, just wait until you hear the boyfriend testify. Everything will be exposed in favor of this defendant. Nope, folks, that didn't happen. Again, I talked about at the beginning the 2 perfect defenses here theoretically, the 1 imperfect defense theoretically, and the wishful thinking theoretically that could apply for the defendant in this case. The one perfect defense, insanity defense, that won't come from these witnesses. It would have to come from the defense psychiatrist and psychologist. But I don't think there's any evidence other than this defendant knew he was shooting at a human being when he fired these shots. And that's not going to meet the threshold for the insanity defense. I don't expect self-defense. Again, all the testimony, all the evidence presented in this cross-examination was that whatever violence Michael Barisone was subject to by these 2 people, it was after he shot them. So it can't have justified the shooting in the first place. So nothing here yet for self-defense. And these were the only other witnesses to the event. So I don't see where evidence of self-defense will come from now, unless Barissone himself takes the witness stand. And would he be believed? I mean, he's already said he has no recollection of firing the shots. He had lost his memory or lost whatever. He has no personal recollection. So how would he testify to an event about which he has no personal recollection? And even if he did, would anyone believe him after what his attorney's been doing through these days of trial, misrepresenting evidence to the jury, being called on it by the judge, called on it by the state? It's absolutely crazy. Imperfect self-defense. Maybe they're going for imperfect. Maybe they're trying to argue that the defendant had a genuine subjective good faith belief in the need to act in self-defense, but we can see that belief was irrational, not objectively reasonable, and you should mitigate murder down to manslaughter. If they were going to do that, they should have just taken a 10-year plea. Or they're going for some similar mitigation down to manslaughter, a diminished capacity kind of defense, basically the same thing. Or they're going for wishful thinking. These people were so vile towards him that you should, if not acquit my client, then certainly mitigate the offense, because just out of emotional sympathy for him, given the terrible things these people had said and done to him and threatened to do to him. But that's not a legal argument. That's an emotional argument. So no, folks, nothing's changed. I don't see anything here for the defense. Sorry. having heard, for all that the cross-examination of the boyfriend was supposed to change my mind, it's changed absolutely nothing. And with that out of the way, let me see now. Let me open up the old lady beating up Andrew in a Durango, Colorado saloon, an Old West saloon, genuinely an Old West saloon. Pretty cool place, actually. The Strader Hotel, they have a saloon/restaurant down in the basement. I recommend it. It's a very old historic hotel. Been there forever. Let me find my old lady. There we go. I found it. Let's see. Now I have to try to size it to the screen appropriately. Let me take care of that, and then I'll set up the background here. It's not it's not quite as dramatic as I might have made it sound, but perhaps still good enough. So what we'll see here is initially my phone. I started recording on my phone because this woman had been pestering me for several minutes now. I had asked her politely to stop. She was physically, so I'm sitting in a bar by myself, just to have dinner. I often sit at bars to have dinner when I'm traveling alone, because why take up a table that could see two people, take money away from the restaurant, take tip money presumably from the wait staff. I just as soon just sit on a stool at the bar, eat by myself, mind my own business. And typically I'll pop open my laptop so I can do some work. In this particular case, I'm looking at a GoPro video that I took on the motorcycle ride. So I have a whole list of files. Video files I'm just looking at. I'm trying to get things organized while I have a free moment. I'm not yet eating. I'm actually waiting for my steak to arrive. I had a ribeye on the way. And this woman kept pestering me and would not go away. And it was sufficient that I started getting concerned that maybe I'd like some documentation of this interaction in case things go sideways. So I had turned on the record video function on my phone. The camera's pointed at my laptop screen. You'll see that at the very beginning. In fact, I'll pull that up right now so we can start right there. Let's see. Where is that video file? Oh, I guess I have to do there we go. Hopefully this will play the audio too. If it doesn't, I'll figure something else out to make sure the audio plays. So we see here, here's my laptop with my video files on from the GoPro camera. I started recording because this woman had already been pestering me for some time, and she just continued. So now I have the phone running, it's recording, and I will turn the camera to face in her direction, so you'll see her on camera, the old lady. She just becomes, she's trying to get my attention. She wants to engage me in conversation or who knows what. I just want to be left alone on my computer and to have my dinner. She's apparently, to my eye, drunk already, or maybe high on something, who knows, but not really acting very rationally. And she's become increasingly obnoxious to the point where the wait staff has noticed. So now one of the kids behind the bar, kid to me, an adult behind the bar, is asking, is everything okay? And I'm saying, well, actually, no, because this woman keeps touching me. And I don't want her to do that. And it's annoying. And they start asking her questions. You can't do that. She says, well, if he didn't want to be bothered, he shouldn't have come to basically to a saloon. Like I'm inviting unsolicited physical contact from an old woman because I decided to eat at the bar. And the guy behind the bar tells her, hey, he's allowed to have a computer here. He's just, if you can't deal with this, you need to go. Do I need to call management or need to call the police? I forget exactly how he puts it. And she realizes that she's going to get rousted out of the joint. In the background, you'll hear a guitar player playing. So there's a little tiny stage with a guy playing the guitar. Very nice guy, tells jokes as he plays. And when she came in, she'd put money in his tip jar. He's got a tip jar by his feet. When she realizes she's going to get kicked out and she grabs her coat, she walks over to the tip jar and takes the money back out of the tip jar. And the guitar player, as she's leaving, he gives her a very polite goodbye. So you'll hear that as well. But anyway, with that introduction, Here is the video. Oh, and the most important part. She takes the tip jar out, walks back over to me, and as she's walking out of the saloon, she punches me in the back on the way out. Now, of course, that's behind me, so we don't see that on video. You'll have to take my word on that one. It was not a particularly painful blow. I wasn't very concerned about it. I was just happy that, I'd be able to wait for my steak and eat dinner and go to bed to continue the rest of my motorcycle trip in the morning without having to pepper spray some old lady in a saloon. So for me, it was a very satisfactory outcome. But yeah, that's the battery. So the old lady punched me in the back on her way out the door to avoid having to deal with the the local constabulary. All right. So with that interaction out of the way, I think I did tip the guitar player. He was pretty good. He was funny. All right, folks. So let's see. Here we go. It only lasts about less than 2 minutes. Oh, no audio. Oh, darn it. I was enjoying this. All right, hold on. I can get this to work. Sorry about that, folks. I just saw the comment now. Darn it. But I did load it up also to our video server, so I should be able to pull it up right here. Thanks for letting me know that, and this should work better. Let's see. Let's give this a shot. Whoops. The video quality may not be quite as good, but yeah, she sounds pretty drunk too. She doesn't just look drunk. She sounds pretty drunk. All right, we should have sound this time. If we don't, I'll keep an eye on the comments. Let me know right away. Here we go. 3, 2, 1. Whoops. Sorry. 3, 2, 1.
It's down. Put it down. Put it down.
Ma'am, I'm just waiting for my meal, and so I can cook.
And the mail means suck the energy out of me. Put that down.
Maybe
and
you
enjoy
could
it.
move over a few feet, ma'am.
I belong. I want you to know me, babe.
Ma'am, stop touching me, please.
You're touching me. You're scared of a woman, aren't you?
I just don't like to be touched by strangers.
Well, then why don't you go into a strange environment instead of people?
Everything okay? Not
No,
really.
I don't think he belongs here with his computer.
Okay, well, there's no problem to have a computer here. Are you okay? She's a little, she's touching me. She's.
No, I don't want to touch you.
We're going to have a problem.
She realizes she's going to get rousted.
I'll be with it.
Do you want me to give her a manager?
Yeah, she knows when the manager comes back, she's getting kicked out. So she takes one more sip of her beer, pretends she's going to wait. And then she walks over. She's walking over to the guitar player now to take the money out of the tip jar. There's the money.
It's because you work this place, boy.
Bam, that was the punch.
Have a great night. Just don't come back here.
Have a great night. Just don't come back here.
Thank you.
That was great. Right then they brought my steak. So perfect timing. Perfect. So that's it, folks. That's what you got to see by hanging out here all the way to the end of today's show. Yep. Sorry, I had to tell her no. I'm a happily married man. That's just the way it is. Anyway, as far as I'm concerned, perfectly happy resolution. I took the punch, guys. I took it. All right, folks, I'm not going to keep you any longer. I do want to take one moment again for those who came in late to remind all of you about our upcoming law of self-defense hard to convict webinars because these seats are going really, really fast. I've only been talking about it a couple days. They're about 3/4 gone already. $50 from Rob. Thank you so much. Nice video, he says. Well, I'm glad I was smart enough to turn my phone on. That proved useful. So we're doing these webinars. We have 5 of them scheduled over the course of April. They're all the same, so please only sign up for one. It's not like they're a series, but they're myth-busting webinars on self-defense law, the kind of myths that can get you sent to prison if you act on them, believe them to be true. So we're going to bust those because they're dangerous to your liberty. We don't charge a penny for these webinars. They're completely free, but there's only 100 seats for each one. And like 3/4 of the seats are already gone. I've only been talking about this for 2 days. So if you're interested in participating in one of these webinars, they're just online, of course, you should sign up sooner rather than later before all the seats are done. And you can do that at lawofselfdefense.com/hard-to-convict, lawofselfdefense.com/hard-to-convict. Tomorrow, Saturday, I don't know. My wife has some, honey-do list stuff I have to do around the house, so I'm not sure if I'll live stream or not tomorrow. Saturday, April 2nd. I'll have to play it by ear. For all of you, thank you so much again I'm so humbled. It's unimaginable to me that people would want to spend so much time listening to a small town lawyer like me jabber away. But I do really appreciate it. Again, if you could hit that subscribe button, the thumbs up, tell friends and family, bring us Law of Self-Defense to their attention. That would be tremendous. Help us grow the Law of Self-Defense community. And with that out of the way, I will just, again, remind everybody that if you carry a gun, so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. Until next time, I remain Attorney Andrew Branker for Law of Self-Defense. Stay safe.